Offices. We believe being part of the community helps us serve the community. We are continually refining our services to make sure we adapt to your changing needs. We also have Florida Association News. That's a free e-newsletter full of resources for associations on industry news, legal issues, events, and education. Ashley, raise your hand in the back, has more information on that if you need it. This session is another example of how we are supporting the community, bringing a class to you locally with your neighboring communities so you can learn the law and share questions and ideas with other associations in the area that are likely experiencing similar challenges. Thanks again for investing your time to come here today, and thank you for serving your communities. To respect everyone's time, we do ask that if you have a property-specific question to your property, that you save it for after class. We will only answer generic questions during the courses. First on the agenda today, Dan Tiernan, COO of Campbell Property Management, will be discussing board member best practices. And then following, our friend Jeff Rembaum in the back will conduct the HOA board certification course. We'll be here until about noon. At the end of the course, please do not forget to pick up your certificate. And just a quick reminder before we get started, if you could please silence your phones. And then if you didn't notice when you were coming in, restrooms are just out into the hall and to the left. Dan?
Great. Hi, good morning, everyone. My name is Dan Tiernan. I'm one of the owners of Campbell. Appreciate you all coming out today. Can you hear me all right?
Yeah.
Okay, great. So as James mentioned, Jeff is going to be talking to you about making sure that you're doing everything legally and being fully compliant. I'm going to talk a little bit more about how to be more efficient and effective. And, you know, the specific area I want to focus on is board meetings. Why board meetings? Board meetings because this is really one of the biggest impressions you're going to make on your homeowners. If you run a good board meeting, it sets a good example, gives people confidence in what you're doing. If you have a dysfunctional, unorganized, poorly run board meeting, you're not going to have the confidence of your owners. So we just want to go over this and try to help you figure out what you can do to be as efficient and effective as possible in running those board meetings. So just a quick show of hands, how many people are new to the board or not on the board or a year or less? Okay, wow, that's half the people. That's great. Okay, how about people between 1 and 5 years experience? All right, more than 5 to 10? So that's 1, 2, 3, 4. All right, anybody with more than 10 years on the board? I have one person back there. Okay, so round of applause to you to serving your community. So the point of that is now you're like my assistant instructor now. So if I say anything wrong or you want to add anything, you just bang the gavel and jump in as we're going along.
Dan, sorry, you got one last year. You want to give it up to someone else?
All right, who's got 8 years? There we go. Jeff Rembaum has been on for 8 years. Dan in front of him there as well. So let's go with those. Jeff will talk anyway. He doesn't need to get out there. So. All right. So the easiest way to get started on this is to figure out what makes for a good board meeting and what our objective is. The easiest way to kind of figure that out is just ask people what makes a bad board meeting. Let's try to figure out what the opposite is. So just ideas, anybody, suggestions? What's a bad board meeting like? What's an attribute of a bad board meeting? Oh, everybody yelling at each other? What else did I hear?
No agenda.
No agenda, that was real bad. Yeah, I'd say, and I heard a lot of different things bounce around, but to me it really ends up being really 3 things. They take too long, nothing gets accomplished, and everybody leaves disappointed or upset. So what our goal today is to talk about how to have a board meeting that you get everything accomplished you intended to, it doesn't take too long, it takes a reasonable amount of time, and everybody leaves happy. That might be a little far reach, but let's say everybody leaves reasonably satisfied. When I say, how long should they take, an ideal target would be, unless you have a really large board or a special meeting that's, with a lot of issues or a major project, an hour is kind of a good standard. So how many of you would say your typical board meeting is an hour or less? Right, about a third. How many people would say it's between an hour and 2 hours? There's another third. How about 2 hours or more? All right, well, good. No? All right, well, one in there. So we really, an hour again is a really good goal, and what we're going to do today is talk about things and hope you get to where you can get everything done in an hour and make everybody happy. So just a quick point on this before we get started. The way we came up with this is really 9 steps to an effective board meeting. I'd love to say that I was smart enough to figure this all out by myself, but what I did was I cheated. Campbell has 136 licensed CAMs, and we get them all together 4 times a year. We get round tables like this, and we talk about different topics. And one of the topics we talked about a few years ago was, hey, what makes for a really effective board meeting? And they all sat and brainstormed and came up with ideas and came up and taught each other about it. We furiously wrote it all down, and that's how we figured it out. That's how we came up with this. And we actually published this. James had mentioned Florida Association News. That's a blog that we have, and there's a blog post in there called 9 Steps to an Effective Board Meeting. So you don't need to write all this down if you want to. You can look it up on the blog, and it'll have all the exact same points in there as well. So again, Florida Association News is readfan.org, and if you're not already registered for it, talk to Ashley. You will if you've given her your email and registered the course, you'll automatically get it. Okay, so the first step in having an effective board meeting is really obvious. It's just making sure you're prepared properly. And I'd say the most important thing here is having a really clear agenda, like that you had mentioned. How many people are here? Is everyone in HOA, or are there any condos? A few condos. Okay. So the agenda. Jeff will talk about this later in his piece, but the agenda is incredibly important from a condo standpoint. HOA is a little more leeway in the level of detail you need to have there. But in general, you really want to make sure you've got a very clear agenda and that these are all items that you're prepared to act on. And the next thing is to make sure you've got a good board package that people, that your manager or whoever administrative staff is getting to you well in advance, at least 3 or 4 business days in advance, so that when you show up to the meeting, you've had time to review everything. You're not getting new information at the board meeting. So I think those are really the 2 most important things in being prepared. And then next is to make sure you've got the everything you need from an equipment and a setup standpoint to be effective. So a lot of times I'd say the most common way that people set up the table at a board meeting would be just a straight line of people and everyone sitting down the line. Is that ideal? Does anyone have a suggestion on what would be the ideal configuration for a table for the board meeting? Circle. Actually, like either a V or a U is great. And why is that? What's that? Yeah, well, that's true. Yeah, circle you'd be at people's backs. But the reason why a U or a V is much better is that it kind of reminds people that it's a board meeting. It's not a members meeting. You all want to be able to see each other and talk to each other. They are the members, the owners that are there. They have a right to listen and observe, but they're really not supposed to be part of the meeting. They have a right to speak, and we'll talk about that later. But it really kind of reinforces that this is a board meeting to be discussing board matters. Another key thing is that you've got a large group like this, making sure that you have a microphone. Especially if you're having a meeting where maybe there's a special assessment or a large project where you're expecting a large crowd of people to show up. What we found out too is that over the last few years, PA systems have always been considered really expensive, but what we found is you can actually buy, actually I've used this a few times where my son had a karaoke box, and I will bring it with me to board meetings. And the karaoke box is actually really good as a PA system. It has a microphone, you can have a little party afterwards, and it's really simple. You can get it from Amazon for about $140. It's a lot easier to do, and you don't need power, you don't need any power for it. And then another important thing, how many people have snowbirds that might be calling in to board meetings remotely, right? So what's the most common way people deal with that? The most common way I've seen people is they take their cell phone and they put it up on speaker and set it in the middle. And it's really difficult. And I know that the traditional Polycom speakerphones, used to cost $600, $800. Now they cost about $200, $300. And there's actually, you can buy wireless speakerphones that will support a group of 7 to 9 people for about $100 on Amazon. And again, you can find the karaoke box information on our blog, Florida Association News, and you can find the same thing about the speakerphone. And if they're wireless, they're battery operated, so you can literally take your phone and that speakerphone, set it up there, and it works great. And then the one other final thing, the great thing to have is how many of you do have gavels for your meeting? A small handful. A gavel, it sounds kind of trivial, but it really is like a universal thing that gets people's attention. It's a lot better than screaming. And
You can handle it too.
yeah, you we'll talk about that later. We're going to try to prevent that from having to happen, but that's another great piece of equipment to have. The next item is really establishing time limits, and what I mean by this is more just planning out your meeting accordingly, so that if you say you've got a discussion on there that, hey, we want to potentially, the association's responsible for the mailboxes, we want to change all the mailboxes out. And you just kind of thought about that, and, that's it. And you want to share your thoughts and put it on the agenda and start talking to the board members about it. And that discussion could go on for 15 or 20 minutes because there's so many different avenues you could go. So that might be something that you might mention at a board meeting and say that you're going to include it in a future meeting, but you really want to make sure someone's thought through, that you have the right to do it, how much it might cost, what the current shape of them are, are we going to try to make a small change, etc. So it's really important to not enter into topics where you're really not prepared. That's where the meetings tend to run off track. And there's also, if you find yourself, and I'm sure this has happened to everybody, where someone's made a motion and you're trying to debate different options to it, and maybe someone's trying to amend it. There's a few key words you can say to kind of say, I want to vote, but I don't want to talk about this anymore. What do you say? Yeah, call the question, right? So you call the question, you can call the question and basically say, listen, we talked about that. Means that's a nice way of saying we talked about this, can we vote already? So that's a nice way to move things along. And in fact, another thing you can do too is that people are discussing things to a certain degree, and maybe you want to move it along, and maybe there's not even been a motion made. You can actually make a motion, even if you believe, if you make a motion, do you have to vote for it? You don't, right? So even if you're sitting there and you know something's not going to pass, and you feel like it's going to go on and on, you can say, I'd like to make a motion to approve the mailboxes, we're going to spend $10,000. I'd like to make a motion, all right, I've made that motion, someone else can second it, and then everyone can vote it down except the one person that wanted it, and then you've at least moved it on. So there's some things like that you can do just very simply that a lot of people don't think about, just to try to make sure you don't waste too much time. But the key thing again is just making sure you don't put items on there that you feel like that you're really not ready to prepare to talk about. Another key thing is declaring the ground rules. This is something that a lot of people, when they first come to an HOA meeting, particularly if you have if your table is set up in a straight line too, they feel almost like they're part of the meeting and they might interject, it might slow things down. It's just important to remind everybody, look, this is a board meeting. This is for us to discuss board matters. You have a limited right to speak, and here's your right to speak. And just making sure that's explained up front. And one of the things we've suggested people do with that is even just have it, say it at the beginning of the meeting. Even maybe include it on the agenda if you've got versions, if you've got copies of the agenda. Yeah.
Because years ago at a board meeting,
They weren't allowed to speak. They could come to the meeting and observe what was happening, but nobody could ask any questions.
Yeah, so the question was, is it new that they're allowed to speak? I don't know when that changed, but it's been quite a while now that they've had. And Jeff will get into the details of kind of when and how they can speak, but they absolutely have a right to speak. And I'm going to actually talk a little bit about that more in a couple of minutes. And one of the reasons I suggest you do this proactively is you never know when someone new is going to show up. So it's best to just say it in advance and have it clear in advance so you don't feel like you're picking on somebody. Because and a lot of people, and I can imagine, if you've been the president and run the board meeting for 10 years and everyone's always behaved themselves and all of a sudden new people start showing up, you might be a little irritated, but they might not even, they just don't understand. So it's a great idea just to make sure before you get started that it's real clear. The next item is making sure you follow the agenda. This is incredibly important. You really shouldn't be discussing things that aren't on the agenda because people, might want to be there if they knew that it was a topic that was going to be considered. Another key thing to think about here is, say you've got, a huge lake restoration project or a clubhouse remodeling that's going to result in a huge special assessment, and all of a sudden you know you're going to get a lot of people out. And you might have 10 items on the agenda. It might take 45 minutes before you even, and this might take 30 minutes in and of its own because it's so large. Do you want to put that at the beginning or the end? When do you want to put that? The end. Anybody else have any suggestions? I always suggest do it at the beginning. And the reason why is that if they're there for that, a lot of times what happens is they're just getting they're wanting to hear about that, so just get to it as quick as possible, and so you can move on. If you've got a big group of people, we always suggest to do it that way. Just get that, because that's the most important matter. Go ahead and get it knocked out at the beginning, and then those people will, they might even want to stay for the rest of the agenda. And the next, again, is this, making sure you let the members speak. One of the nuances of this is that it's actually, I've seen situations where the boards would discuss a huge, mailbox project or a clubhouse remodel or lake restoration. They would discuss this in great detail, and they would debate and add all this input, and then they would vote on it. And then at the very end of the meeting, they wouldn't allow anyone to ask any questions or speak at all until the very end of the meeting, after the decisions are all made. And you can do that, but it's really not very respectful. So what we always suggest is that, the board speaks, particularly if it's a big project like that, say it's a mailbox project, you talk about the vendors, you talk about what you might want to do, and then after you've made all your points, and then you can let owners speak for a few minutes and give them their opportunities. You might find out that one of them owns a mailbox manufacturing company and he can get you a good deal, or something's changed in lakeshore restoration and geotubes aren't the best thing anymore and you ought to use a different methodology. You never know what you might have out there. So it's always a good idea to let them get their input in a controlled fashion before you actually make the vote. And the next item is making sure that Robert's Rules is great from a general decorum and how you should do things standard, but it can get very complicated. And so is anyone in here? Would anyone consider themselves like a Robert's Rules expert in here? Expert. Okay. So apparently, occasionally I find people in the audience that they're like Robert's Rules ninjas. And I would tell you, if you have that skill, don't use it on the rest of your board members. It's not fair. It's like I'm a black belt and someone else is a white belt. It's just not fair. Because a lot of it is utterly irrelevant. And the most important things you need to be able to do are establish a quorum, open the meeting, establish a quorum, make motions, seconds, understand, how to get the votes done, adjourning meetings. Really simple stuff. Call the question would be like a blue belt kind of thing, and just try to get the basics down. But if you have someone that is really an expert in this, wants to show off all their ability, you got to make sure they're not going to confuse everyone else in the process. It might be better to have somebody else actually run it. Yes?
If you're going to conduct your board meeting in the auspices of Robert's Rules of Sturgis, does that have to be in the bylaws?
So that's a great question. We'll save that one for Jeff, because that's a legal question. All right. The next one is this might be the most important one to help make sure that you display yourselves effectively to your homeowners, and that is, does anyone know where I got this from? Don't criticize, condemn, or complain. Who said this? So this is a Dale Carnegie quote. So how to win friends and influence people. So you know, if you've been on the board for more than a year or two, I'm sure you can remember a situation. Well, how many of you can remember a situation where you were going to go into a board meeting and somebody was going to be rude or yell at you or say something offensive? How many of you kind of know that was coming in advance? Okay. All right. So did any of you sit down and did any of you sit down in advance and say to yourself, all right, they're going to say something really nasty. How am I going to respond and practice it? So as simple as maybe it's, thank you for your input, although I believe what you said is libelous and slanderous and completely untrue. We're going to move on to the next topic. As opposed to you, whatever. It's amazing the calm that brings. Yeah,
That's what the gavel is for.
well, the gavel's too, but I would say it more the way I just said it, because that's, the gavel's a little argumentative. If they don't stop, you can use the gavel. But the lighter you can be, and it's amazing, if you say something like that, it just lets all your energy out, and if you kind of know what you've really told them, but you feel better about it. So it's really, I'd say the most important thing is just, be prepared for it and try to handle it as coolly as you can, and show that you're not going to lose your composure. Because it is we talked about it, James and I and other managers we work with. We'll talk about certain communities just have a hostile attitude, and it breeds over the years, and it takes time to break that. So, this is, I've been in a lot of different businesses in my life, and this one is really unique because it's very emotional, because everybody lives, you all live together. You're neighbors, you can't leave, or if you do, I mean, you have to move. So it really is important if you can find ways to try to be as nice about this as possible, even when people are being horribly unreasonable. Most people really are nice in the end. They just have gotten a little crazy about a certain issue. If you can keep it calm, that's great, because you don't want to become known as one of those nasty communities. Yes?
Isn't that the nice thing about Robert's rules, that you control how long somebody can work?
Well, it's the nice thing about any kind of rules is that the rules should give you some decorum and some control, but a lot of people just break it, right? And
We
so.
put that in where it's 3 minutes, like 3 minutes.
Yeah, absolutely, absolutely. Yeah, you definitely need time limits, but sometimes it just doesn't. People don't play by the rules. So, yes.
Dan, how would you respond to someone when you go in and introduce yourself, that was going to be a new board member, and she says, well, I'm here for revenge?
That's a good one. Okay, so if someone responds, I'm here for revenge, well, I would say, well, that's really interesting. Maybe we should talk about that afterwards. I'd love to learn more about what it is you're trying to
She's no longer
revenge.
on the board. She's no longer on the board. She didn't last long.
Yeah. No, it's funny. Those are difficult conversations. I would tell you, if you've got an environment that is that hostile. I was actually, as I was driving up here, I was listening to a podcast about an African-American guy that basically was meeting with KKK people and getting them and basically helping them understand their position and change. And it's like, look, that guy can have a civil conversation and help people rethink their way they're thinking and things. Anybody can. So, again, just try to be as patient as you can when you're going into these things. Recognize your position and be prepared for the worst. And don't fight back. Don't hit back the way you get hit. The last one here is real important, and you can ask Jeff about this. He'll explain this in detail. How many of you have heard people talk about, and have had boards talk about they want to have transparency? Transparency is a great word, and one of the key ways I've seen a lot of new boards say we're going to be transparent. So if people can't come to these meetings, when we write the meeting minutes, we're going to put everything that everyone said and all the things that happened, so that even if they miss that meeting, they'll know exactly what happened and what was said. That's a wonderful goal, and it's a horrible idea. So the reason why, and Jeff will be able to talk to you about this, but minutes, the first thing that happens if there's a bad accident or a slip and fall or a death or a traffic accident or someone drowns in a pool, is somebody goes back and looks at the minutes and sees and they find in there 5 years ago someone said this, the board member so-and-so said that this exit was a death trap. Okay, regardless of the fact that then later on they went and commissioned the city to try to get a stoplight. They worked with the Florida Department of Transportation to try to make things happen. All of this happened, but it was still like a $20 million judgment, and it was largely based on that. So, yes.
So are you saying not to produce minutes distributed to the community?
No, I'm not saying that at all. I'm saying they're not transcripts. What you need to have in your minutes are basically the bare minimum. It's open the meeting, who's attended, who the quorum was, what the motion was, and who voted for it, who voted against, and that's it.
Okay.
You don't need things about, I think there's a trip hazard, in the sidewalk, and this has been happening more and more. You might want to say that. It's a perfectly good thing to say, and the manager needs to act on it, but you don't need all that in the minutes. That's the point. It's a shame that we live in a society that we have to be this way. It's the nature of what we're dealing with. Yes.
So that's come up before, but it's not the HOA's responsibility for the sidewalks. So someone tripped and fell and broke the wrist, and I don't think it's in our minutes. We made note of it. We try and get it repaired and fixed, but it hasn't been fixed. So it almost takes the liability away from each other.
Yeah, that might. I was thinking about ones where it is the responsibility of the HOA or oak trees, but even still, you could put it in there that someone needs to talk to the city about it to get it done. Yeah. But yeah, I would let Jeff just help you on that. Again, it should just be motions and that. And one of the most famous things I've heard people say, I'd like the minutes to reflect. So if someone says, I'd like to make the minutes to reflect, what do you do with that? Nothing. you don't. That's not the point of the minutes. The minutes aren't to make sure that individual person's point was properly captured. The minutes are for the benefit of the association. That's it, period. So, real key point. So again, this is all on Florida Association News. Lots of articles in there, lots of information you can get. If you're not already subscribed, or if you don't have your email, you can go to getfan.org. And then also on Campbell's website, you can find, for those of you that are new board members, we have on the front page, you can see a board member primer that you just put your email address and we'll send it to you. It's a 12-page document that describes kind of the roles and responsibilities of new board members and all the different officer positions. And we picked out about a dozen articles that from Florida Association News that we think will be really helpful. Things like, how to be politically smart, 10 worst mistakes that most new board members make, things like that, how to deal with angry homeowners, just a lot of things that maybe it seems common sense, but until you've done it for a while, it takes a little while to get all that. So that's it. So thank you guys very much. Does anybody have any last minute questions before okay, great. So I'm going to turn it over now to Jeff Rembaum, and he'll
Morning.
Morning.
I'm not here today. We have some IT issues to contend with. We'll take those moments. responsible for the material as much as the legislature is for writing it. Can you hear me okay?
Yes.
Outstanding. All right, we'll get the show on the road. So welcome to the Homeowner Association Board Member Certification class. It is different than the Condominium Board Member Certification class. There are some subtle differences. I saw some hands go up. Where are my condo board members? I will try to include some information for you on the larger distinction points, but in order to do the combined lecture, it's almost a 3.5, 4-hour lecture compared to today, which is really focusing on homeowner association. So your first lesson as condo board members is, you better believe that there's a difference between a condo and an HOA in the legislation. And I will point out some of the bigger stuff, but you do need to take yourselves to a condominium board member certification class at some point in the future. Now, Kaye Bender Rembaum, who are we? What are we? We are at the moment 19 lawyers, soon 20, growing. And all we do is represent Florida's community associations, condos, HOAs, cooperatives, occasionally a developer when they're building out communities. I think there's a group here from tradition. We represent the master. You'll see me out there from time to time, so I am welcome. We have 8 attorneys. Hopefully it'll be a few more this year, but 8 of us are board certified in the body of law as experts. This seminar, we're here today on behalf of Campbell, and thank you for having us here. I truly appreciate that opportunity. If you ever need legal representation, then please think of us. If you're happy with your current counsel, then you stay right there. If you're looking for a new management company and you're not with Campbell, I suggest to you very, very seriously give them an opportunity to meet with your board. They have a whole lot to offer. They're one of the top management groups in the state of Florida, without a doubt. We have a new seminar. We offer these, in case you want to do it again, condo members, in case you want to do the condominium board member certification class. You can do that. We offer them for free in the office once a month, Wednesday nights. They are small, they are intimate, up to about 15, 18 people only. And I think HOA is the second Wednesday, condo is the third Wednesday. And we started to offer, and we do different classes from time to time. One of the new ones we're offering this year, and we're doing it in conjunction with the Insurance Office of America, is entitled Director and Officer Liability Insurance. Think you're covered, think again. And it goes through all the problems in the Director Officer Liability Insurance policy and the gaps you want to be concerned about if you are a board member to make sure you have proper coverage. Today, I am going to bore you with a whole bunch of fun subjects, including the applicability of the relevant statutes, transfer fees, estoppels, members' meetings, elections, board of directors, functioning. A few gems all board members should know, where I'm going to run through a whole bunch of topics very quickly. Budget, special assessments, reserves, financial reports, contracts and bids, use right suspension, voting suspension and fining, covenant enforceability, architectural standards, official records, assessments and foreclosures, insurance, Federal Fair Housing Act, assistance animals, recall, and turnover time permitting. If I were to give you the presentation in advance, because you're going to go home with an exact replica of what you see on the screen, with the exception of one slide, and I will fill you in when we get there so you can take notes. But I cannot do every single slide, but I will try to touch on every single subject. So I will be talking and you will be wrestling with the pages trying to figure out where I am. So I've learned over the years, the best thing for me to do is just talk and have a nice hour and a half, 2 hours with you nice people, and make sure you go home with some homework, which will be an exact replica of what you see on the screen today, with the exception of that one slide, because you have homework. When you go home, you need to read your declaration, articles, and bylaws one time from the beginning to the end. Read through the seminar material one time. It is especially wonderful if you have insomnia. Leave it near the bed. Read just a little few pages here and there. I guarantee you within 10 minutes you will be sleeping. Leave it there. Over the year, you might get through all the material before you awake in the morning, feeling refreshed and wonderful. All right, let's Rembaum's Association Roundup. Not enough of you, shame. All right, I put out an article every 2 weeks, every 3 weeks or so electronically. Some of them on a monthly basis get published in the Community Association Journal, which is why I was asking the question before. That's the home for the column. But I also deliver them electronically via email to your inbox so that you can stay up to date with new laws affecting HOAs, condos, how they've been interpreted, new court cases that affect us all really in this line of work, so that you can be a better and more productive board member. If ever, by virtue of being here today, you will start receiving it, and we'll add you to the email distribution list. If you receive it and you don't want it anymore for any reason, you had enough, I quit, you're off the board, fine. You might still want it, great. If you don't, there's a button at the bottom, click unsubscribe, and even I can't be at you if you call me up and ask me to. All right, so there. I think that is all the housekeeping I need for today. Why are we here? We're here because the legislature says within 90 days after being elected or appointed to the board, you have to be certified. I know y'all are certifiable because you volunteered to be on your board. I'm included. I'm 8 years on my board. I almost got a gavel out of it. Darn it. 1 year I'll get it. I'll be the longest time of anybody in the room. Maybe next year. There's 2 ways to be certified. 1, lie on an 8.5 by 11 piece of paper. I mean, not joking. On an 8.5 by 11 piece of paper, write down that you read the governing documents. You're going to work to uphold them and you faithfully discharge your duties. Signed, Jeff Rembaum, poof, I'm certified. Because if you're not certified within 90 days, you are temporarily suspended from service until you are certified. So there's really no reason to not be certified, right? Just do that on a piece of paper, turn it in, poof, you're certified. But you didn't learn anything. So then take yourself to a class like this, like good people are here, so that you actually learn the material that you need to help you be a better, more productive board member. You can certify up to 1 year in advance. But if you have a break in service, even for a microsecond, you quit 1 day, you're back, they appoint you back on the board the next. That's a break in service, you have to be recertified. Okay, everybody's clear on that? Yay. The association, there's all kinds of what I like to call legislative hiccups for camels. Camel is really just a horse with a top on the back. Most of the association's records have to be kept for a minimum of 7 years. Why Tallahassee's legislature chose to make it a requirement for the association to hold on to the certification, you're going to go home today with one. Where are they? In the back? You hold it up because I want everyone to see it. The yellow forms, little certificate. So there it is. So you have to go home with one of those, but you can't get one until after the class, and then you go home with one. I would tell you to give it to the association secretary, because if there was a test, that is who you're supposed to give it to. But there'll be no test, don't worry. You're going to give it to the manager. But I would highly suggest to you make a photocopy of it, keep 1 copy in your house, and give one to the manager. That way, if it ever is questioned, hey, where's your certification, and the association can't find the record, you will have that record at home. In any event, the association is legally obligated to hang on to them for 5 years. If, in fact, somebody is on the board and they are not certified and decisions are made, well, as soon as you know they're not certified after 90 days, then they are temporarily suspended from service until they are certified. But what about all the decisions that were made? The entire board is not certified for a year. Does that mean all the decisions are disturbable? No. Legislation says not a single decision made if you weren't certified and should have been are disturbable because you weren't certified. Okay. Chapter 720 Florida Statutes, purposes, rules of interpretation, and conflicts. First, some subtle differences between the HOA homeowner association and condominium. Condominium owners, you only have your condominium because of Chapter 718 Florida Statute. If we were to remove Chapter 718 from our legislation, then your condominium building would lose its designation for all intents and purposes, and you would just have a quote-unquote building. So living in a condominium is a statutory way of life. Homeowner associations are creatures of common law. We don't need Chapter 720. We have it. It provides substantial guidance for those associations. But a homeowner association is not a creature of law, so to speak. So there's a big difference. HOA is common law, condominium statutory law in terms of their creation. The HOA, it owns the common areas in its own name. In other words, excuse me, something on my screen. Back. Where were we? Yep. The HOA owns the common areas in its name. The company owns them. Whereas in a condominium, you don't have a common area, you have common elements. And all of the owners own an indivisible interest in those common elements. There is a big difference there. More on that later. In an HOA, the default is the board would decide a material alteration. The condo, the HOA gazebo blew down. Do we want to put it back? We want to change the color of the clubhouse. We want to change the color of the gazebo. Unless the governing documents say otherwise, all those decisions are vested to the board of directors. In the condo, nope. 75% of the owners have to approve any material alteration, changing the color of the outside of the building, refabricating the furniture in the downstairs lobby. All material alterations, all requiring a vote of the membership. The HOA declaration is not a title document, whereas a declaration of condominium is, and I'll explain what I mean. It is important for Marketable Record Title Act purposes, probably for you HOA board members, one of the most important things I will talk about, so I know why, at least I haven't bored you in tears yet, but I still have your attention. I will talk about the Marketable Record Title Act, now this MARTA, nothing to do with the Atlanta bus system, for those of you from Atlanta. When I record a declaration of condominium, the units spring into life. When you buy a condo unit, really what you're buying is a thin layer of paint. Behind it is drywall. The lower level of the upper surface, the upper surface of the lower surface, the parametrical boundaries where it all comes together, the outermost layer of the drywall, be it wallpaper or paint. That is your condominium unit. So really, you bought a cube of air bound by paint. That's your condominium unit. But it's still a unit. How are we gonna, if I wanted to sell you a piece of property, we're all on the beach together, and I'm showing you this beautiful condo, how would you like to own that cube of air 100 feet up and 10 feet over? You think I was crazy. But if I go and report a condominium declaration, that unit exists. Assessments are due. All right. In the public records on your deed as a condo owner, it says you own unit, whatever number, unit 101 of the Campbell Property Management condominium, and that's what it says on the deed as recorded in that certain declaration of condominium, and then it gives the official record book and page. No question about the applicability of the declaration of condominium. When you buy in an HOA, you're buying a lot. Lot 15 of the Gardens Hunt Club plat. There is no reference to the declaration. So, Florida has some legislation, and there are exceptions to it. Condo, you are accepted. You can fall asleep for the next 30 seconds on this part. HOA, this is the most important, one of the most important things I'll talk about. Because not sooner than 30 years after your declaration is initially recorded, it begins to expire on a lot-by-lot basis. If you imagine being in court trying to do a covenant enforceability or foreclosure, and the defense is the covenants have expired. If you're within a year from the initial date of reporting, a year within the 30th year, then you need to be talking to the association lawyer yesterday. There are really easy things to do to prevent the Marketable Record Title Act from affecting your governing documents. But if you don't, it is a very expensive fix and requires a vote of the community and all sorts of hoops. We've got to go to Tallahassee as well, and there are some things that have to be done with the legislature in order to get those documents alive again. It can be done, but expect to spend between $15,000 and $30,000 before you're done. No need to even ever worry about that. So when you go home and you do your homework, because I know you will, when you look at your declaration, homeowner association board members, very first page will have the recording there. It'll tell you the date it was initially recorded. If you're within 30 years, if you're close to that 30-year mark, talk to the association's lawyer. I'm not going to give you a whole lecture in Marketable Record Title Act today. Just know that that's an urgent issue that must be done. The purpose of Chapter 720 is to gives statutory recognition to corporations that operate residential communities, to provide for procedures to protect the rights of the members without unduly impairing the ability of the association. Chapter 720 would not apply to any commercial or industrial non-residential parcels that might still be within the graphical depiction, the boundaries, if you will, that your homeowner association declaration is subject to. So land is subjected to that declaration. You could have residential and commercial. The declaration will still apply to the commercial parcels, but Chapter 720 would not. That kind of makes sense. All right, I'm going to make you all lawyers for a few minutes. We're going to talk about constitutional lawyers. Contract law. We want to talk about, and this will apply to Chapter 718. And for those who aren't familiar with the numbers, when I say 718, I'm referring to the Condominium Act. When I say 720, I'm referring to the Homeowner Association Act. So, legislature, I don't know why, but every year, just about every year, they love to tinker with the community association legislation. Does that new law apply to us? Well, if you have language in your declaration that we lawyers refer to as Kaufman language because we borrow concepts from cases. So Kaufman language is real simple. It means this. Somewhere in that declaration it says, this declaration is subject to Chapter 720 as amended from time to time. Not as amended, there's a court case out there. If you wrote, this declaration is subject to Chapter 720 as amended, well then it means as amended through that date of the legislation. Whereas when you say as amended from time to time, it means any legislative change applies to us. If you have Kaufman language, never ask the question, you know that new legislation applies. Well, if you don't have Kaufman language, which most of you probably do not, then does that new law apply to us? And the question becomes, is it a procedural law or is it a substantive law? If it's a procedural law, it will apply. If it's a substantive law, it won't. What's the difference? Glad you asked. How much time do you have? It is wide open in terms of the differences, but we know a few. Procedural is how we do something. Legislation came out and said, unless your governing documents provide otherwise, you need 7 days notice for a board meeting. It's only 48 hours. But if they said that, change it from 48 hours to 7 days. Would that affect all of us in the room? Yeah, it would. It's procedural. It's how you do something. Can the legislature come out and change your assessment regime that is set out in your homeowner association declaration or declaration of condominium? No. The declaration is a contract. It's a contract between you and the company, the association. We have constitutional protection against government interference in existing contracts. So with that in mind, they can't change your assessment obligation, they can't change the size of your lot, then they can't take away an appurtenance to your lot. Whenever you see the word appurtenance in your declaration, make a mental note. Please substitute the word connected to. The balcony is appurtenant to the unit, connected to. The parking space that is deeded along with the unit is appurtenant to the unit, connected to. So that will help you in your interpretation when you look at your own declaration later in the week. All right. What if we have conflict between Chapter 617, which I'll tell you what that is, 720, or 617 and 718? The 617 is the Not-for-Profit Act, Chapter 617, Florida statutes. Before your declaration ever got recorded in the county's public records, first, a company was created with the Division of Corporations up in Tallahassee. That is Chapter 617. What if there is a conflict? And sometimes there is in the legislation. In the event of any conflict between the provisions of Chapter 617 and Chapter 720, along with Chapter 718, the provisions of those other chapters apply. This law is near and dear to my heart because I wrote this one about 12 years ago, 14 years ago, a long time ago. But the governor of the state of Florida asked the business law section of the Florida Bar to update the Not-for-Profit Act for the state. That would have had huge repercussions on our community associations. We had to make sure that didn't happen. So this particular legislation is a result of making sure that doesn't happen. So when there's a conflict, remember, 720 applies. Now, what if there's a conflict between your declaration, your articles, and your bylaws? What is the order of priority? What do we do then? The declaration says we need to give 4 days notice. The bylaws, 3 days. The article, 1 day. Which one do we follow? How do we know? And you will see some of these latent ambiguities. Sometimes they're more patent, more visible, if you will. Sometimes they're hidden. How many people remember that 1970s Brill Green commercial? A little dab will do you. Anybody? Good, because that's how you're going to remember the answer to this conundrum. What do we do when there's a conflict in our own governing documents? A little dab will do you. Declaration, articles, bylaws, then rules and regulation. That is the order of priority. So, if there's a conflict between the deck and the articles, you're going to follow the deck. Articles and bylaws, you're going to follow the articles. You get the idea. Okay, moving on. Transfer fees and Estoppel certificates. I'm not going to spend a whole lot of time on this subject matter, but it does bear a few moments of our attention. A transfer fee. You want to buy or sell property? And we're going to say, well, you need to pay 1/4 of the annual assessments. Be nice if we could do that, right? We want to get some extra revenue for the association. We amend our declaration. Any new homeowner who purchases has to pay the association 1/4 of the annual assessment. Capital contribution on the way in. Fine. The law hates transfer fees. They find them to be an unreasonable restraint on the alienation of property. Well, plain English, alienation just means transfer. An unreasonable requirement on the transfer of property. However, why didn't you tell me that one happened? Oh, like turn around, let's go. That's so weird. That's never happened before. Sorry. Are we back? Yes? Right now. So let's get to the right view. So we're talking about the transfer fee. There is an exception for homeowner associations to be able to charge this transfer fee, this capital contribution, if you will. The exception is for any fee, charge, assessment, fine, or other amount payable to a homeowner's condominium, cooperative, mobile home, property owner association pursuant to any applicable declaration, covenant, or law. And the list goes on, you can continue reading. However, this is in 689.28 Florida statutes. Condominium board members, where are you again by a show of hands? I'm just making sure you stay awake. That is your exercise. Yay. In Chapter 718, you can only charge up to $100. That's it for the transfer fee. I don't care that the background check cost you $400. You can charge up to $100 for that transfer fee. That's it. 718. So when we have conflict here, we have a specific legislation governing condos in Chapter 718 that says no to the transfer fee. There are lawyers who are trying to do class action lawsuits against condominium associations charging anything more than that $100 transfer fee. If you are charging one, please talk to your lawyer. HOAs, have a good time, charge whatever you like within reason. The Estoppel certificates, oh boy, we had a problem on the west coast of Florida. Someday that lawyer was charging unreasonable amounts of money on estoppels, where it was like an almost like commercial transaction setting where there was vacant land and there were 100 estoppels and the guy was charging an unreasonable amount of money for each one, when in fact it just should have been one low estoppel. Well, that problem found its way to the Florida legislature, and effective July 1st, 2017, we get a whole bunch of new estoppel requirements. Number one, you have to issue it within 10 days. And if you don't, you can't charge for it. All right. That is the important thing to know about that. There's many other requirements. I'm not jumping through them all. There are requirements of what should be in it. The date that you issue it, the name of the owner as reflected in the books and records, the property address, whether or not there's a parking space associated with it, the attorney's name and phone number, a fee for the preparation and delivery of the estoppel certificate, the name of the requesting party, the amount of the assessments, the date the assessment is paid through, the date the next assessment is due, an itemized list of all assessments, including special assessments, etc., and so forth. whether a capital contribution or resale fee is required. And the list goes on, but look at number 2, whether there is any open violation of a rule or regulation noticed previously to the owner of the property in the official records. So, here's a question for you. We have the declaration, articles, bylaws. Chapter 720 defines the term governing documents to mean declaration, articles, bylaws. This year, they added rules and regulations to be within the definition of the term governing documents. It also says in chapter 720, the governing documents must be recorded. So when you do the math, for the first time in HOA history, the legislation now says, without saying it directly, but the governing documents have to be recorded. Rules and regulations are within the definition of governing documents. So what has to be recorded that never had to be recorded before in the public records? Your rules and regulations. And I guarantee you, if you take an owner to court on a rule and regulation violation, I'm talking about board-adopted rules and regulations, and you take that owner to court, and that owner hires me or someone like me, we're going to defend that case based on the fact you didn't record the rule. So you can't violate someone if you haven't done your part, what you're supposed to do as well. But in any event, here's the question going back to the Estoppel, whether there's any open violation of a rule or regulation. So in this HOA declaration, there was a requirement for a particular paint color. It was actually in the declaration. Well, is that a rule or regulation that needed to be, there was a violation because the house was the wrong color. So the question became, could the association go against the new owner because the house was the wrong color? It was a violation of the declaration, not a violation of the small r rules and regulations. So can the association now enforce it against the new owner? Great question. We were debating that last night in the office. Please submit all questions in triplicate, hand them to the nice people in the back. They will give them to me. We will answer questions at the end of the lecture. I only have a limited amount of time with you. If you go home with a question that is your fault, there will be a time for questions, but I can't do it like Dan does in between while we lecture, or we will never get out of here and we will lose focus. So I do apologize in advance for that, but it's just too much material that I need to give to you guys. So if you bear with me, there will be a time for questions. Please do write them down so we don't lose track of them. And I will stick around afterward. We'll do an open question and answer, and then I will stick around if we're not able to get to everybody's question before it's said and done. And I think we have a break at some point in this particular lecture. What time is that at? Okay, so maybe right around that time, if you let me know about maybe 5 to 7 minutes in advance, then maybe we'll stop and we'll do some questions then we'll take our break, and then we'll come back for the second half, and we'll do more questions at the end. Okay, the legislation dictates the amount of money that can be charged for the Estoppel fee. Remember that if you don't provide it within 10 days, you can't charge for the fee. For other information, you can read that on your own. The Estoppel certificate delivered is good for 30 days. If you deliver it by mail, it's good for up to 35 days. If you want to amend it, let's hypothetically say you put out a Estoppel and there was no special assessment, but within the next 30 days and before the closing, a special assessment was levied by the board. The new owner has a pretty good argument that he doesn't have to pay that special assessment because you didn't disclose it on the Estoppel. You have every right to amend the Estoppel, and if you don't, you probably cannot collect that special assessment from that new owner. So you can amend, but you cannot charge the owner for that amendment. If it goes beyond the 30 or 35 days and they need a revised Estoppel, sure, go ahead and charge them. It's like a new Estoppel, basically. But if you're voluntarily amending it because circumstances change and you need to let that new prospective owner know before the closing, you can't charge for that. Many times the lenders want additional information. It goes beyond what's in the Estoppel. I like this particular piece of legislation because an association or its agent may charge, management company, you should like it too, an association or its agent may charge a reasonable fee to the prospective purchaser current owner, member for providing good faith responses to requests for information on or behalf of the prospective purchaser, other than that is required by law, so not the Estoppel information, so long as the fee doesn't exceed $150 plus cost of photocopying and any attorney's fees without a limit. So they better be careful what they ask for. Maybe we usually make it big up front for that kind of information. Okay. Now we're going to start jumping into the heart of the matter. We're going to talk about members' meetings. That will lead us into elections, which will lead us into your board service. We'll start with member meetings section. These references are for those that are not aware. Nevertheless, that's a statutory section, 720.306. If you want to see all of Chapter 720, you can send me an email. I can send you a link, but you can just do a Google search, much easier. You can go to the Senate website. All the Florida statutes are there. They're in the public records. There's a variety of ways to get to Florida statutes. When you do, just make sure you look at what year that is, what year of the statute you are looking at. It's usually in the top center of the screen, but wherever, the last thing you want to do is be reading something and then find out it was from 1962. Not a good idea. I guarantee it'll be different. All right. Annual members meeting. The association must hold a meeting of its members annually, once a year, in accordance with the bylaws. That's where the election takes place. Special members meeting refers to membership meetings other than the annual meeting. The board of directors can call special meetings. 10% of the membership can petition the board to hold a special members meeting. The special and annual members meeting, notices and agenda. All notices must provide for date, time, and location. Whenever we're talking about a meeting of the membership, whenever we're talking about an assessment that's going to be levied, be it an annual assessment or special assessment, whenever we're going to talk about a rule that's going to be adopted by the board that affects how someone can use their lot, not a rule for the clubhouse, a rule that affects somebody on their own lot, those items require a 14-day meeting notice unless a greater period is required in your documents, usually in the bylaws somewhere. But these are the sacrosanct 14-day meeting notice requirements. Now, if members opt in writing, you can stop having to use postage stamps and snail mail for your meeting notices. You can use them for elections as well. But members must opt in. I, Jeffrey Rembaum, hereby agree. I don't want you to send me U.S. mail anymore, and I want to receive all of my communications from the association electronically to this email address. The statute doesn't require the board to offer this. If a member wants it and you don't want to offer it, you don't have to. But more and more associations are certainly taking advantage of the email notice provisions within the statute. There's also closed circuit TV requirements there in the presentation, but I'm not going to go through them this morning. Annual members meeting. I'm going to teach you what Dan would probably rather I don't. And that is that, at least in the law, the annual members meeting does not need to include the purpose for the meeting. But why, in the Lord's name, would you not put the purpose for the meeting in the meeting notice? Same thing for board meetings, by the way. Condos, you are required to have an agenda. Absolutely every board meeting. HOA board meeting, you're not required to put out the agenda. Condos, you can only talk about the agenda items at your condominium board meeting absent an emergency. HOA board meeting, you can talk about what's on the agenda and anything else you want. No requirement to stick to the agenda, so they settle difference there for sure. Bottom line is, more likely than not, your bylaws require you to post an agenda for you HOA board members, so even if the law doesn't require it, more likely than not, your bylaws do. And I'll go back to what I said at the beginning. If you're having a meeting, why wouldn't you want to let the members know what the meeting is about in the first place? If you're having a special members meeting, you must include the purpose of the meeting on the meeting notice. It's just the annual one that doesn't have to happen. Member participation. I'm going to cover this topic right now for members meetings and board meetings because it is pretty much much identical. So, owners have a right to attend all meetings of the membership and to speak at any meeting with reference to all items open for discussion, all items on the agenda. If we were in a condo board cert class, that first one that says all items open for discussion wouldn't be there because you condo board members are limited to the agenda. Members have 3 minutes that they can speak. You all, as board members and the board, have the opportunity to adopt reasonable rules governing the frequency, duration, and manner of the owner statements. So with that in mind, when associations ask me to go to meetings, it's for one of two reasons. Either it's a technical issue and they're dealing with an issue where they want the lawyer to explain things to the members, or we're going through something with the board. Another reason is because everybody is at everybody's throats. The board can't even have a cup of coffee together without trying to support it on each other. I've been to those meetings, and first thing I did when I walked in the door with a smile was, you would be surprised if you could just practice in front of a mirror with a smile. I don't know what I'm happy about right now, but I'm happy. I'm happy to be here. But if you approach your membership with a smile, when they come up and talk to you and they're all pissed off, it is going to go light years towards diffusing a situation. The other thing that goes towards diffusing a situation is letting them know you're going to listen. That is member participation. So, we can adopt reasonable rules. All right, you're limited to 3 minutes. Just because you ask a question doesn't obligate the board to answer. We can if we want to, but we don't have to. If the board, in its reasonable discretion, would like to provide more than 3 minutes to a member, it can. No member may give their 3 minutes to another member. And the list goes on and on, you get the idea. But if you put these on the bottom of your agenda, every member will know they're going to get that opportunity to speak. Because you're also going to include in the rules how. So, the board will consider, the board is talking about an item. If no motion is made before going on to the next item, every member gets their opportunity to address the board. Of course, one of the rules is you're limiting their right to speak to whatever the item is that the board is discussing, so they can't go off on a tangent. If a motion is made and it receives a second, the board, uninterrupted by the members, will continue its conversation. When the board is done, then member comments will be solicited for up to 3 minutes each. Thereafter, it will go back to the board for final conversation and the vote of the board. And if the members know that when you ever have a contentious issue, you will completely diffuse it and have a much happier room if everybody knows that they're going to be heard and they're going to have a right to speak, and when that right to speak, when they will get that right to speak. Everybody clear on that? I'm going to take it for now, yes. Quorum requirements for a membership meeting. Unless a lower number is provided in the bylaws, it's 30% of the membership constitutes a quorum. Unless otherwise provided, somewhere in the governing documents, it's a majority of the voting interests present in person or by proxy that decide the issues that are brought to the members. First and foremost, show me where it says the board can make that decision. A member comes up to you and asks, I have the governing documents. I've lived in this community for 30 years. I know them forwards and backwards. Show me where it says you, the board, have the power to make this decision. Boy, that stumped me as a young lawyer, first year in practice, going to a meeting. I'll never forget the lady that did that to me. And I stood there like a stump on the log. I didn't have a good answer until about a year later. Year 2 maybe in practice. It's been well over 20 now. And it dawned on me that was the wrong question that lady asked. You had one of those epiphanies when you wake up. Every decision not specifically reserved to the membership is to be made by the board of directors. And that's in the legislation. And that's where your power comes from to make decisions. So unless the members, somewhere in the governing documents or in the statute, have the right to make a decision, it falls to the board to make those decisions. Are you clear on that? Typically, when you amend your governing documents, it's a 67% or so threshold of everybody. When you are doing other things, such as perhaps you're waiving reserves, we'll talk about reserves later, that would be a majority of a quorum at the meeting. I want to talk about the quorum for a minute. I want to pretend we're all on the board together. We have 100 members at our HOA. How many people make our quorum? 30, right? If 30 people walk in the door, how many people do I need, generally speaking, to have something pass? 16, right? A majority of the 30. Now, 50 people walk in the door. What's my quorum? 50. My quorum is 50. I have 50 people walk in the door. My quorum, minimum quorum requirement, 30% is 30. But what is the quorum today? 50 people walked in the door. So what's my quorum? 50. Now we have that same, we're voting on something, and it's a majority of the quorum. So how many votes do we need at that meeting? How many? 26, right? Is that what you guys said? Good. So if 100 people walk in the door, what's our quorum? 100. How many votes do we need there? 51. So this is the point we're going. As the quorum changes, so too do the votes required that you need for something to pass. I once had a group misunderstand that, where they thought in all these examples we gave, if the minimum quorum, they had 100, minimum quorum was 30, then they only needed 16, regardless of the quorum that was in the room. And that was incorrect, right? That was wrong. So as the quorum changes, so too does the number of votes needed for something to pass, unless somewhere in the law or the governing documents they're requiring a certain percentage of the entire membership. Then all of a sudden that quorum requirement is not as important, because we don't need the majority of the quorum per se. We need the majority of the whole community, or we need a supermajority of the whole community, whatever the case may be. 2/3 of all the voting interest typically is the default to amend your governing documents, declaration, articles, bylaws, unless the governing document provides otherwise. Proxies. As a board member, proxies are how you get things done. They're your best friend. They're cute little critters. Please don't kill the proxy. You can kill proxies. Here's what a proxy is. I can't go to the meeting. I give Olivia, one of our attorneys in the back of the room, I give to Olivia my proxy to go vote on my behalf. That's a proxy. The proxy is good for 90 days for the date of the meeting for which it is intended. So, we go to the meeting. Olivia goes to the meeting with my proxy, and there isn't a quorum. Or they have a quorum, but not enough votes. At that meeting, you can suspend the meeting to a time, date, place certain. You can meet every day. You can meet every 30 days. You can meet on the 90th day. But on the 91st day, all those proxies die. All right, so proxies are great because if you're trying to amend your governing documents, you're trying to get something passed by the membership, you actually have a 90-day window to do it, so long as at the first meeting where you're using those proxies, that if you're going to continue the meeting, you actually put that into the minutes, that the meeting is continued until the time, date, place certain. You miss one of those three, you kill the proxies. Nothing I can do to revitalize it, nothing I can do to start over again. Two kinds of proxies, general and limited. General, I give my proxy to Olivia. She can vote her conscience, whatever she wants. Limited, I am directing her how to vote on a particular issue. She must vote the way I am telling her to. All right? Let's talk a little bit about board elections. Ooh, condominium members. Before I get too much further, I did have a mental note. Your quorum requirement is not 30%. It is a majority of the voting interests. So if you have 100 members, you need 51 to make the quorum. Election of directors must be conducted in accordance with the procedures set forth in the governing documents. In the old days, up until, Olivia, this is one of the slides I was talking about that I changed up this morning. In the past, if you didn't get a quorum at your annual meeting, you had 5 open seats. I don't care if 3 people were running or 20 people were running for those seats, you didn't get a quorum. Last year's board rolls over. And that's how it was for many, many, many years. Until July 1st, 2019, we have a new wrinkle. And this is not in the presentation. So this is what, if you're going to write anything down, it's this one. The second bullet point, starting with the green language. All right? So, no quorum means last year's board rolls over, unless an election is not required because, and there are 3 requirements for this to happen. There are either an equal number or fewer qualified candidates than vacancies exist. So we have 4 spots, we have 4 or less people running. And if nominations from the floor are not required, meaning nothing in the governing document saying we must accept nominations from the floor, and write-in nominations are not permitted, meaning somewhere in the governing documents it says no write-in nominations, then those folks that were running are on the board, even if you didn't get a quorum. That's a big change from last year's board rolling over to these candidates being seated, but only if those conditions are met. That may or may not affect you, I don't know. Term of office is typically 1 year unless otherwise provided for in the governing documents. Effective July 1st, 2013, if the election process as set forth in the governing documents allows candidates to be nominated in advance, then you're not necessarily required to allow nominations at the meeting. That's something the board should decide ahead of time. Personally, if you're thinking of amending and restating your governing documents, you want to bring them into the 21st century, which if you haven't done, you probably should think about doing at some point. One of the things I like to do is remove the quorum requirement completely from the election process. So no quorum is needed, simply following the condominium regime, the way they do it, is so long as 20% of the eligible voters cast a ballot, you have an election. I think that gives us all a much better chance, especially if you have voter apathy in your community. Some do, some don't. Well, if you've been convicted of a felony, you are not eligible to serve on the board unless your civil rights have been restored for 5 years. If you have pending charges of felony theft or embezzlement, then you cannot serve on the board. If you are delinquent in a monetary obligation, you owe 1 penny to the association. On the last day, the last moment in time you declare your candidacy, you are not qualified to run, which is different than being delinquent once you're on the board. And when you are delinquent greater than 90 days, then you are off the board by operation of law. Big difference between them. The election is typically a 14-day meeting notice. We talked about that. The quorum is typically 30% unless the governing documents provide for a lower number. You cannot, there's no cumulative voting, if you will. You can't take all 4 votes and vote them for 1 person. You can vote for less people if you want to. There's 4 people running for 4 seats, then you can, well, no, let me rephrase it. 8 people running. 8 people running for 4 seats. You have 4 votes. You can only use them 1 per person. You don't have to use them all, and you can't stack them all 4 for 1 person. All right. You're upset with the election. You want to challenge it. You cannot challenge an election within the first 60 days. You cannot challenge an election within the last 60 days. So a great part of the year you can live trouble-free from the members saying, I'm going to write to Tallahassee because this, I don't know why he was doing that. I'm going to stop looking back there so it's not doing it. Must be some other signal in the building that's jumping in. Slide 36. Okay, election day. Please remember to notice an organizational meeting to take place after the election. You don't want to wait 2 weeks to know who the president is. What if there's an emergency? So at least come out of the annual meeting with a president, vice president, secretary, treasurer. You can always change the officers whenever you want, and we'll talk more about that in a few minutes, but at least have your board seated. You can vote electronically if the association decides to opt into electronic voting. You can read about that more on your own. Election of officers, we just started talking about that. This is the one time the board can vote in secret, and I don't mean away from the members. What I mean is if any one board member wants the vote to be in secret, then the board sitting at the front table, in front of all the members, can scribble on a piece of paper the name of the candidate they want to be president, vice president, secretary, or treasurer as we go through the list, and then those little pieces of paper will be tallied up and nobody will know who voted for who. So secret, yes. but secret doesn't mean away from the eyes of the membership. Okay? What do you do with a president that doesn't listen, that won't put something on the agenda? It's so simple. I move Joe's no longer the president. I move that Mike is the president. Okay. You can do that. Nothing says you can't do that. You can change officers every week if you would like to. I don't suggest you do that, but you could. So just know you can always change up the officerial positions. Now here's a good question for all you Robert Rules aficionados. Does the president vote? You think so?
Yes, sir.
By a show of hands, how many people think the president votes? By a show of hands, how many people think the president doesn't vote? Okay? What if I could convince all of you nice people in the next 60 seconds that the president doesn't vote, the vice president doesn't vote, the secretary doesn't vote, and the treasurer doesn't vote? Someone say go. Go. Thank you. Here's why. You're not voting as an officer of the company. You're voting as a director. The question is irrelevant to begin with. We are incestuous in our community associations. There is no requirement that the officers be board members unless it's required in the governing documents. It's not required in Chapter 720. It's not required in Chapter 718. So you can have your board of directors, and the officers can be comprised of completely different people. Heck, directors and officers don't even have to be members and owners in the community as per Chapter 720. Now, that requirement might be in your governing document somewhere, which is why you need to read them. See, there's lots of little things in them that you need to know. But in the law, officers and directors don't have to live in the community, and the officers don't have to come from the directors. So, does the president vote? No. Why not? Because he's not voting as an officer, he's voting as a director. Everybody clear on that? I think I would. I'd like to think so. Board of Directors, the great power grab. Unless otherwise provided, the corporate powers of a corporation not for profit are exercised by the board. We talked about that. Unless delegated, no one board member gets to make decisions for the board unless it's an emergency. The board is responsible for the maintenance of the association. It went out again, didn't it? Property, health, safety, and welfare powers. These are the police powers. They're constitutional police powers. Health, safety, welfare. Let's hypothetically say that you have a problem in your community that requires a special assessment. You need a vote of the membership. And the members will not vote in favor of it despite your best intent. Now what? Let's say you're in an HOA and you have this 100-foot seawall, and the seawall is collapsing and it's going to cause all kinds of erosion and all kinds of damage, yada, to the clubhouse, yada, yada. Well, there's a case out there, but this is from a real case, Tiffany Plaza, big condominium down south, and the building engineer said that all kinds of concrete restoration work had to be done, millions of dollars. And of course, the governing documents required a special assessment, vote of the membership, and the members voted it down. What do you think the board did? They did what they thought they needed to do, which was they levied the assessment. So what do you think the members, some of the members did? Sued them. What do you think the appellate court said to those members when it finally found its way through the court system? What do you members, I'm paraphrasing. What do you members, stupid? You have trained professionals telling you your life is in jeopardy and your building is in jeopardy at the next high surf if you don't do these things. Board, you did the right thing. From that case and some others, we have a line of cases that when there's health, safety, welfare at issue, police powers, true constitutional police powers, then don't think don't give up hope. That's my bottom line. You can't do this on your own to do that end run that I'm sharing with you around the governing documents. All sorts of things have to be done at the lawyer level to perfect that, if you will. All right? But I just want you to be aware of it. So if you do find yourself in that situation, be sure to talk to the association's attorney. All right, board voting and decision. You cannot vote by proxy or secret ballot as a board member, but except for the election of officers. Board members, yay, one of my favorite conversations coming up. Members of the board may use email as a means of communication, but may not cast a vote on an association matter via email. No board member, not even the president, should make unilateral decisions unless it's an emergency or that power has been delegated. And the standard to which you are held is reasonable business judgment. That means you could be wrong all the time. I hope you're not. But you could be as long as you acted reasonably. Condominium board members, you have the same standard except for the purchase of insurance. When it comes to purchase of insurance, you must use your best efforts. That's a relatively new change in the law a few years back. We haven't had a significant windstorm that really caused enough damage to really test out that law. But I feel sorry for the condominium board that doesn't have, where they didn't acquire the proper insurance pursuant to the governing documents. God forbid there's a casualty, the building has damage, and they don't have the right coverage. Because reasonable business judgment, you could be right, you could be wrong. That standard, let's say it's here. When you're talking about a best effort standard, it's way up here, up toward the ceiling, in terms of doing what is right. Okay? So bear that in mind. Okay. So, members of the board can use email as a means of communication. All right, board members, we're all on the board together, make life easy for our HOA. Can we have dinner together? Can we go to the movies together? By being together, are we doing something wrong?
No.
By a show of hands. How many people think we are doing something wrong if the board is just together? Okay, that is wrong. The board can absolutely be together. We're having Friday night fried chicken dinner, all of us at my house. We're all on the board together. That is perfectly okay, not a darn thing wrong. Clear? Good. Now it gets turned. So, at this Friday night fried chicken dinner where we're all together, we start talking about the swimming pool. We start talking about the paint flaking off the clubhouse. We recognize we want to put it on the agenda. Are we doing anything wrong? Don't answer that one yet. Because I want to go to the next example, and let's say we step in. We decided at that dinner we're going to fire Sally, hire Tom. Can we all agree that we made a decision outside of a properly noticed meeting and shame on us? Yes? I knew we could find some agreement somewhere. Now, when that happens, and it will happen, you will accidentally step in the proverbial pool at some point during the year. I hope you don't, but you probably will. You simply ratify it at the next board meeting. You do a mea culpa, you come clean. You put it on the agenda. Ratification of whatever the act was. Ratification of prior decision regarding swimming pool, whatever. And then at the board meeting, I move that we fire, whatever I just said a second ago, fire Sally, hire Mike, or vice versa. Second, all those in favor? Aye, it passes. Now, even if a member is upset that you made a decision, technically, yeah, you did something wrong, but you also cleaned it up. All right, so that's how you clean it up. You do not use that as a way of life. You just use the ratification process when you accidentally make a decision outside of a properly noticed meeting. Now, let's go back to having that discussion at the dinner table. And we were discussing the swimming pool. That was our murky one. Did we do something wrong? By discussing association business. And I'm going to tell you where I come down on this, and different lawyers probably have different thoughts on it, but I always thought that that is okay, and that is not a meeting that required notice unless you met with regularity. You start to meet with regularity, it changes the conundrum a little bit. There's something else I need to point out that is very relevant to the analysis. There's a difference for HOA and condo on this. Condominium board members, I regret to tell you that every single committee meeting must be noticed, just like it was a board meeting, and minutes taken, unless you have an exemption for that committee meeting in your bylaws. So yes, the bake sale committee is subject to the meeting notice requirements in a condominium unless exempted in the bylaws. In HOA, it's almost exactly the opposite. If you're dealing with final expenditure of association funds or ARC matters, architectural, then the architectural committee is meeting. Those are the two that require meeting notices. Everything else doesn't for the HOA. So it's very different. So if the board could meet as a committee, as an executive committee, could it, to tee things up on a regular basis? I suppose it could. I personally prefer transparency. So I would rather, if you're going to meet with regularity, that you notice the meeting, even if you don't have to. But the fact that we were all at my dinner table discussing association matters because we were on the board together and we were having dinner and talked about what we want to talk about at the upcoming board meeting, that is fine. Somewhere along the way, the line gets blurred if you keep doing that with regularity, and you might be exposing yourself some way. And also remember that the membership, don't ever expect them to understand this. The fact that we didn't close the blinds having dinner, shame on us, because every member that walks by the house seeing us having dinner together thinks we're up to no good, for the same reason some of you thought we were up to no good when we were just together, right? So that is a misconception there. So you want to avoid that. All right. Board meeting notices typically are 48 hours. If your governing documents require a 3-day, 72-hour notice, be provided to the specific board members who need to do that, but there's also the posting of the 48 hours in advance. When you're dealing, we talked about this earlier, when you're dealing with non-emergency special assessments, or you're talking about special assessments, you were talking about an amendment at the board level, an amendment to a rule regarding how they can use their lot, whatever that rule may be. No loud music that I can hear from the street can come from your home after 8 o'clock at night. Well, that would be a rule that would require a 14-day meeting notice. Condominium board members, what if we had a rule that said, this applies to you too, what if we had a rule and we adopted it that says no towels off the balcony? Is that a 48-hour or a 14-day meeting notice for the board? Anybody? Okay, anybody can answer that. It's actually going to be a 48-hour, it's a trick question, because the balcony in the condominium is a limited common element, it's not part of each unit. Compensation. There is a way to get paid. It's jumping through some loops. Don't get paid as an officer director of a Florida Community Association. And you have a contract between an association and a director. I cannot go into the condominium conflict of interest portion. It is very different than this particular section. However, please know that it's a silly thing to do in the first place. I will not practice law for my association. Why would you want to be a vendor for your association? There's so much work out there. And if things go south, you're still living there. So you might want to think twice about that. But there is a way to have a contract between the association and a director. It will require 2/3 of all of the directors present. The contract must be fair and reasonable, and it must be disclosed to the membership at the next membership meeting, and upon any member's motion, the contract can be canceled by a majority vote at the members present at the meeting. You are guilty until proven innocent. A director or officer charged by information or indictment with a felony, theft, or embezzlement involving association funds or property is removed from office. So you haven't been found guilty, but you're charged. Yeah, I know, that's what I got. Really annoying. But we will need to. Maybe you look at Google after the project.
I want to Google it right now.
You're going to Google why is it?
Why is this happening?
I like that. Nope, well, we are back. All right. So guilty until proven innocent. You get charged, you are off. An excessive gift. On behalf of yourselves, immediate family, an officer, director, manager must not solicit, offer to accept, or accept any good or service of value for which consideration money has not been provided from any person providing or proposing to provide goods or services to the association. However, an officer, director, or manager may accept food at a business meeting with a value of less than $25 per person, a service or good received in connection with the trade fair or educational program. Here's a weird thing, no one ever talks about this one. If the board finds that an officer or director violates this subsection of statute, the board will immediately remove the officer or director from office, and the vacancy is filled according to law until the end of the director's term. Wait a minute, how do you recall someone on a board, on a community association board? It takes a majority vote of the entire community. Where is the accused director's right to defend themselves in this process? What about the nefarious board that says, I saw you out to dinner with the landscaper, I saw the landscaper pick up the check, and I know Cafe Chardonnay doesn't have anything less than $25. So therefore, I moved Joe's off the board. We didn't like Joe in the first place. That particular piece of legislation is a recipe for disaster one day. I have never seen it be abused yet, thank God, but it is a very strange statute to have it that way, where the board can remove a fellow board member. You know, in chapter, we talked about conflict between 720, 718, and the Not-for-Profit Act, 617. One of those happens to be how you remove a board member. Remember, our legislation says you need a majority of the entire membership in order to take someone off the board, whereas in chapter 617, it's a whole lot easier for the board acting as a board to remove a fellow board member, so there's a conflict there. They can,
Excuse me, in that situation that you just described, that
you just hold that for a couple minutes, and I'm gonna come right back to it, like 1 and 2 over there. 5 minutes of break. Well then, yeah. I'm going to get to the end of this section, then take questions, and we have about 3 or 4 more slides. So, vacancies. The board fills the vacancies by board decision. Joe quits, Alice quits, board just fills that spot. Member participation at board meetings, we already think, board and member meetings we talked about. Recording, every member has a right to audio tape and videotape member and board meetings. You can't stop them. You can adopt reasonable rules and regulations governing their participation. Board meetings must be held at a location that is accessible to the physically handicapped if requested by a physically handicapped person who has a right to attend the meeting. Committees, we talked about this a few minutes ago. HOA committees subject to the meeting notice requirements. Again, when a final decision is made regarding expenditure of association funds and ARC decisions to approve and disapprove, that type of thing, when the ARC committee, architectural committee is meeting. What do a golem and board workshop have in common? A golem, they're both mythical creations. That's what they have in common. It's nice when people actually get this one. Mythical golem is summoned by German Jews as a protector and guardian. The term workshop is used as a mythical tool to get around noticing a board or committee meetings. Potato, call it what you want to. We know when you're having a board meeting and not a quote-unquote workshop. A meeting of the board, when does a meeting of board members become a board meeting? Clearly, we talked about that. When a decision is made, we know that's a meeting that required notice. We know if we're just discussing innocently now and then board business, that didn't trigger it. Yet we know if you start to meet with regularity, it might be stepping in the proverbial bill and you probably should do meeting notices at that point. You work so hard. Last slide before I take questions. How to get on the board? How do you get off? When I have fellow board members say I quit, walk out the door, come back. They say, you quit. Yeah, but I didn't quit in writing. So, do a lousy job, piss off the members, get yourself recalled by a majority of the community. Don't be certified. Steal from your association. Take an excessive gift from a vendor. Resign in writing, or don't pay a monetary obligation greater than 90 days. All 6 of those are guaranteed to get you off the board of directors. The easiest one is probably number 5, resign in writing. So, with that in mind, I'm going to take 5 minutes of questions, then we're going to break for 5. How long do we break for? 5 minutes? 10 minutes?
Yeah, 5 minutes.
5 minutes. So we're going to come back with it. We're going to say 5 minutes so that we start with a 10. But I will do questions now. David, you had the first one, and this gentleman had the second one, then whatever else we have time for.
Pass on my question.
Okay, and the gentleman in the orange.
On the previous slide, you were talking about doing the rule for $25 rule.
Yes.
And would that also take effect if your declaration said how to remove a board member? Which one would supersede?
That's a community, that's an issue where I want you to actually read the provision that you're talking about. When we're talking about removal, we're dealing with items of procedure, right? So typically that I would lean toward the legislative way of removing somebody. But for all I know, your association as a lawyer may feel differently and feel as though that provision, there's 2 ways to remove board members. One through that provision, the other one, and then how the court's going to deal with that, I think that would be a novel issue for professional. And I'm not aware of any cases that deal with that particular issue. Might be, doesn't come up all that often. Yes?
If you do a board officer election and secret ballot, do the board members have a right to ask for the ballots or to see the official results? Or do they know, do they just get to be told so-and-so is president, their vice president? Do they
When
get to
I'm at an
know?
annual meeting, and I'm going to one tonight, I don't like to announce the losers. I don't like to announce the vote count.
No, this is the officer election. For board officers,
Oh,
the organization.
No, I would always say it's 3-2. It's 5-1. I would always announce the count results.
Do you have to?
No.
Can you say no?
I would suppose you could say no, but remember that's a record of the association, and it needs to be saved. So those little scraps of paper need to be saved.
Even if it's secret ballot?
Yeah, you don't know who wrote on it.
Okay.
Sir?
Thanks for taking my question. You mentioned earlier about members being able to speak at all board meetings.
And membership meetings.
Does that include the annual budget meeting?
Of course.
Gotcha.
All right, oh, one more.
Well, you said the notice term workshop. Suppose you're going to paint your community in a committee.
I'm sorry, you're going to take your community and?
You're going to paint houses.
Okay.
And you ought to be the same color.
Okay.
So you're deciding on a color to be presented to the membership. You will appoint a paint committee. Some of whom may be on the board of directors, some may not. Can those people meet without notice to?
I think you are acting as an ARC. You didn't call it an architectural control committee, but you're dealing with architectural control issues. I think that that itself is enough to trigger that 14-day meeting with this board. Okay, we're going to break for 5 minutes. 5. We're starting in 6 minutes at 10 till. Because I got a whole bunch of stuff I want to share with you all. If there are we'd like to get started again. Please find your seats. We have only 3 hours left together. So you can tell I try to keep it interesting. And please understand I was completely joking when I said submit your questions in triplicate, so people went to the back and were asking where the forms were. So I'm just kidding. If you leave with a question, just come on up. You know, at some point we'll get to your question, even if it's after everything is done and you're your copy. All right, a few gems all board members should know. Drafting minutes, parcel access, material alterations, amendments, rules and regulations, MARTA, which we talked about, assistance animals, process servers, managers, off-site warranties, emergency powers, driver's licenses, and I moved assistance animals out of this section, so we need to change slide 56. Olivia's taking notes for me in the back on certain slides. Okay, minutes. We're going to see when we get a change to the iPad and see if it works any better or not. Minutes, board and member meeting. Oh boy. Joe thought the pool was too green. Sally was upset with the leaves floating in the surface. He thought it looked great. Joe, what is that doing in the minutes? I have seen minutes, and I'm not kidding, they're almost verbatim what people say. Oh my God, no. I completely agree with what Dan said. It's just a scant recitation of the business that took place. Anything else is bound to get you in trouble when, God forbid, a lawsuit is going on and you have all this copious information for the adverse side. Pick on you. So be smart. Make sure the business shows up. Motion made. Here, I think I even have an example. Did I put it in this one? Yes. Minutes example. Discussion by board regarding cable bill. Board concern invoice incorrect. Motion by Joe to have manager not pay invoice until cable company confirms amount due. Seconded by Alice. Board discussion followed by member comment. Chair called the question. Tally result was unanimous. Get the idea? Less is more. Right of access to parcels. The governing documents may. Doesn't say must, doesn't say shall. May, permissive. The governing documents may grant the association a right to access an individual parcel in emergency circumstances or for purposes of undertaking an owner's maintenance obligation on the lot in the event the owner fails to properly maintain. Fine. What about getting your fees back at the association level? Well, you need some additional language in your governing document that you may or may not have. If you haven't amended them to include this language, when you do your next amendments, or if you want to talk about amending and restating the entire declaration, this is one of the items. One, giving the association the power to enter a lot for purposes of maintenance if the member doesn't do it. And secondly, to create a new category of assessment. We talked about general assessments, we talked about special assessments. What about, well, let's come up with a new term, individual assessment, where the same obligations to pay the assessment if the association had to perform the maintenance obligation and the owner failed to. So now we call it an assessment. Now it can be liened and foreclosed. You can't lien and foreclose fines. That's a very different conversation. Condos, you cannot lien and foreclose a fine under any circumstances. HOAs, you can lien and foreclose if you can fine greater than $1,000 per violation and you amend your governing documents to allow it in the first place. Then you can do that. So there is difference between HOA and condo on that item. Material alterations. We briefly touched on it before, but we get a great definition as to what it is from a case, Sterling Village, years ago. Means to palpably or perceptibly vary or change the form, shape, elements, or specifications of a building from its original design or plan or existing condition in such a manner as to appreciably affect or influence its function, use, appearance. Someone spent a lot of time trying to come up with those words. I think we did a pretty good job. Ooh, housekeeping. In your presentation materials is a form. It is this one, if I may borrow it. It says HOA board member certification. We are required by state to have these from you. So in order to give you your certificate, you will have to fill this out. You'll hand it to the nice folks at the table. You will get a copy of the presentation from today. You will also get your certificate to take home and do what with? Photocopy it so you keep one in the association. Okay, moving on. Amending your governing documents. We talked about that earlier. It's 2/3 of the membership unless the governing documents provide otherwise. We had the conversation about the need to record your rules and regulations, right? That was earlier, so I'm not going to revisit that issue at the moment. Sometimes governing documents require lender consent in order to amend certain provisions. Legislation has now provided us a way to acquire that if necessary. All right, let's see. This goes into detail on the need to record the rules and regulations because they were added to the terms of governing documents, Chapter 720, which requires the recording of the governing documents in the county's public records. These are the minimum categories of rules you guys should have in your association. If you don't, you should think about having them. Number one, official record requests, where they have to be sent, things like that. The member's right to speak at board and membership meetings. We talked about rules and regulations if it makes sense under that circumstance. Rules governing animal conduct and cleaning up after an animal. How people use the common areas and the architectural provisions, which is a big one. We're going to come back to the ARC point in just a few minutes. All right, so you are expert on rule adoption, and you know at the board level, first and foremost, you must have the power to adopt the rule in the first place. Somehow you have to extract that power from your governing documents. You can't just create a rule because you want to. You gotta have the power to create that category of a rule. Then, if it affects a lot, you know it's a 14-day meeting notice. And whenever we talk about a 14-day, I don't know if I said this before, not only are we posting it, but we have to send it to all of the membership. So anytime we're dealing with that 14-day notice, it has the added requirement of sending it, and whoever does the mailing has to put an affidavit into the meeting minute, to be kept with the meeting minutes, that they did the mailing. Other than that, you have the 48-hour meeting notice, which is the typical monthly board meeting notice. Okay, this goes into more detail on reporting the rules and regulations and why you should do it. Florida Marketable Record Title Act, we talked about. Olivia, please make a note, please, on slide 65. There are simple ways now to preserve the governing documents. It's before the 30 years. After the 30 years goes by from the date of the initial report, you need a vote of the community in order to revitalize. You need consent from Tallahassee, all sorts of things. Beforehand, you can preserve them as long as you do this action at the board level before that 30th year. And there are different ways to preserve, but it's very simple to do. It costs between $500 and $1,000 at the worst case, probably, to preserve. Whereas before, as I was explaining to you, it's about $15,000 to $30,000 probably if you have to revitalize. More information you can go through. Service of process. The process server comes to the gate, you're a gated community. Do you have to let him in? Yes, you do. Can you say, Joe, run, the process server's coming to get you? No, you can't. If you want, you can have a security guard follow the process server. But that's about all you can do. All right? Process server is allowed into the condominium building. They are allowed into our gated communities to effectuate the service of process. For those unfamiliar with the term, that's where the sheriff's officer is coming to say, you have been sued. Sign here, please. And they give you a copy of the complaint. When is a licensed manager, community association manager, required? When you have someone who is doing the following. Oh, and this slide has to change too. 68. Is that number 50? Well, we'll get there.
Go to 68.
You saying something else before that, or you're just telling me that it's blank?
Transfer to the next one.
Let's spend some time on this issue. All right, this week. Community association management means any of the following. Controlling or dispersing funds, preparing budgets, other financial documents, assisting in the noticing of meetings, coordinating maintenance activity, and other day-to-day services involved in the operation of the community association. When it's done for, number one, remuneration, and when the association has 10 or more units, and I believe it's a budget of 100,000. That financial number may have been lowered, because that's when you need a licensed community association manager. If you're paying somebody, they need to be licensed, bottom line. I mean, when you look at it that way. Anybody in a recently turned over community? Just one? Okay. How long ago?
About a month.
Oh, all right. In that case, I will share with you an interesting case. If you live in a condo, the best example, I want to talk about the implied warranty of habitability. Something you definitely didn't wake up this morning thinking you were going to learn about. The implied warranty of habitability. You have a right to get to your home. You have a right to get to your unit in the condominium. If the condominium elevator doesn't work, and it hasn't worked correctly, and it wasn't maintained correctly, you have a claim against the builder, the developer, for a breach of the implied warranty of habitability. I cannot get to my unit to habitate it. If the roads flood all the time, you might have a claim for the implied warranty of habitability. And in fact, something like that, the community got flooded over and over. There was some problem in the community, so the association sued the developer under that theory, and a bunch of other claims too, but one of them was the implied warranty of fitness of habitability. And during the litigation, legislation came out and it said you can't sue an HOA developer under the theory of the implied warranty of habitability. So the trial court, threw the case out. Appellate court said no. That law was in effect when you filed the complaint. So for that association, you still have that claim. But for any other association that hadn't filed that claim yet, you no longer have the implied warranty of habitability claim in your bag of tricks to torment the developer with after turnover. That was where that was going. And we can talk more about turnover issues another time. You have emergency powers. Something to think about, especially in the HOAs, is a set of walkie-talkies, a pencil, a piece of paper, and a disposable camera. You might be, in an emergency circumstance, the last board member standing and the only one around. And the trees may have fallen down, and other sewer issues, and you might have to make decisions that are going to cost $10,000, $20,000, $50,000 on the fly, and there's no other board members around to talk to because they went out of state when the storm was coming. Well, if you have a disposable camera, that might come in handy, because that iPhone we all use to take pictures with, well, the power's been out for a week now. All the 911, all the cell towers, all their battery backups have failed. So you might also want to think about having a set of walkie-talkies at the association, so during a storm, the board can be in touch with itself. All right, when the phones go down, you guys can still talk to each other. You have lots of powers. You can even create assessments without meetings. You can do all kinds of things when you read through this list, but only when there is a state of emergency as declared by the governor. All right, you can read about those powers later. This is the board member emergency kit that I think you should have. If your lake starts to overflow, that's part of your surface water drainage system. A lake. Do you know who to call to open the weir? David, not you. Where's David? David, please. You don't see David? Okay. He knows a whole lot. Let's see. Driver's licenses. For those of you that have gated communities, you cannot swipe the magnetic strip of the driver's license. You can record, you can make a photocopy of the front of it, you just can't collect the data that is on the magnetic strip. Budgets, special assessments, reserves. All right. A budget is an estimate of what we're going to spend next year. If we want to spend money for a new front pedestrian gate, it's not in our budget, yet we have the money in our bank account because we're doing better on our budgeted items. We didn't spend as much as we thought. Do we have to amend the budget before we can spend the money on the pedestrian gate? No, we do not. It doesn't matter on a legal level if all the expenditures differ greatly from what is in the budget. You do, however, want to use the budget as an instrumental tool. You do want to compare last year's expenditures to last year's budget so that you can properly prepare for this year's budget. Special assessments. Typically, absent the Tiffany Plaza scenario, we'll find a vote of the membership is required. Sometimes it's not required. Sometimes that power might be vested to the board. It's a community by community basis. We can look at the governing documents on that. You know, it's a 14-day meeting notice. Anytime you're dealing with the budget, anytime you're dealing with an assessment, which includes special assessments. What about reserves? Condos. You are required to have reserves every year, no matter what. HOAs. You don't have reserves unless initially created by the developer or voted on and established by the membership. Then you have statutory reserves. The fact that you have the word reserve on your budget is not necessarily indicative that you have a statutory reserve. And if it's not a statutory reserve, then those monies can be used for any pet project your board wants. Got that? A forced savings account for a future board use wonder. That's the way I look at it. So, protect that money. If you're saving money for the roads, the sidewalks, whatever it may be, take a vote of the membership, create the statutory reserve. Here's the implication. Once you create it, you have to fund it every year. So, now we have reserves, whether you're a condo or an HOA. Created the statutory reserve at the HOA level condo, you automatically have the reserve. And the board has a choice to make on a year-by-year basis. It can, if it wants to, provide the opportunity to the membership to vote to waive or reduce the reserve amount. So you first figure out the useful life of the component, do the math, how much money do we have a year that we need to put aside, set aside for this component, all right? Now, the board decides, as it's preparing the budget, does it want to present to the membership the opportunity to waive or reduce in whatever percentage the board wants to allow the members to reduce it by a certain percentage. Everybody clear on it? Any questions on reserves? Now, David, you're back. We talked about surface water drainage. And I said, well, you're my one expert. Question? Yes?
You said the board may allow membership to vote on waiving or reducing the reserve. Does that mean the board has an option to not let it?
Correct, and fully funded.
So that's the other side of the coin.
Sure, if you don't present that opportunity.
Fully funded.
Correct.
And is it correct that the law now says that if you establish a reserve fund now, that you can decide to fund it over a number of years to catch it up? As opposed to
I'm not sure where you're going with that. I haven't heard anything like that. What you can do, other than waiving and reducing, now keep going, I'm just trying to understand.
I've been told that if we set up a reserve fund today, and I have a parking building that has used the life of 30 years, and it's 28 years old, but the day I establish the reserve fund, the membership has to fund 28 years worth of replacement.
That would be correct unless you wanted to wait, because you have 2 years left. So in the next 2 years, you got to set aside all the money for the reserve that should be there, unless you present the membership the opportunity to waive and reduce, which you could have done when you set up the reserve in the first place. In that instance, I would get creative on that one. Then that's an issue for that association to deal with its lawyer, et cetera. Absolutely. So remember that anytime at a board meeting you're dealing with an assessment or special assessment, you must include on the meeting notice assessments will be considered and the purpose of the assessment. Special assessment has some additional requirements we'll get to at some point. Let's see. And special assessments, remember, and budget, 14-day, minimum 14-day, or some of your bylaws require 30. I've even seen 60-day meeting notice requirements before the budget adoption, unless your governing documents require the board to provide a copy of the budget to all the owners before the meeting. The board is not required to actually send the budget out in advance. I think it's a nice thing to do. After the budget is adopted, then the association must provide each member with a copy of the budget, or that a copy is available to them upon request. And we kind of talked about that already. Just jumping through some of these. I don't have the list with me, but there are minimum subjects that need to be within the budget for condominiums. It's in the legislation, so you need to be aware of that. Special assessments, notice of meeting must include a statement that a special assessment will be considered, nature of the assessment, and the estimated cost of the assessment. We talked about reserves in the beginning. We talked about the 2 ways to create the reserves, either by the developer or the membership vote. Next slide will tell you all about computing reserves. You can also vote the membership. Once you create the statutory reserve, you might have 3 different reserves. You could vote to pool them together. That's a membership vote. This is for condos and HOAs. You can go from pooling to straight line to pooling by membership vote. You can even use the money for a different purpose by membership vote. There lies the difference. Financial reports. Okay. This financial reporting is based on the size of your budget, right? And there are the criteria. These are the level. And I said by budget, but it's really the revenues that are received. And so you're 150 to 300, you're compiled, 300, 500, you're reviewed, et cetera, and so forth. Put slide 89 down, please, Libby. And what I want you to know about this is it's a strict requirement as to when the member is entitled to that report. And it is typically not later than 120 days after the end of the fiscal year. Division condos, very important. HOAs, I haven't seen it happen yet, but it could. You're 1 day late right now. This happened to a client. They were within a week of being late. So I'm exaggerating by saying they were 1 day late, but they were within 7 days or whatever it was of being late. They got fined well over $3,000 by the Division of Condominium. The division has said, if you condos don't put these reports out on a timely basis and a complaint is made to us, we will fine you. I once had a client, this is before they were doing this, a few years back, they were delinquent 3 years running. Oh my God. First year, we took care of it with a hand slap. The next year was about $3,000. The next year, the third time was like close to $7,000. But in any event, there are minimum fines that they must assess, and they're going to assess. They've made it very clear. So make sure you get your financial reports done in the requisite time. You can change the reporting level. The board, on its own, can always decide to do a higher level of reporting. If you want to do a lower level of reporting, that's a decision for the membership to make. Contracts and bids. One of the more misunderstood, I think. How many bids do you have to get? 3, right? Where did that ever come from? Who said it first and why? Statute says bids. Doesn't say 3, 4, or 2. So minimally it's 2 when it's required. And when is it required? That is when the actual cost of the contract is more than 10% of the total budget, including the reserves. It's the only time. And there are exceptions. What if you need metal stairs? And there's only one company in the county that produces the metal stairs. Are you going to have to get another bid? Probably not under that circumstance. So there is some requirements. Also, condos, we did not talk about websites at all, but all your official records basically need to be posted up there, including all contracts in existence, and a summary of bids or the actual bids need to get onto your website. These contracts are exempt from the bidding requirements. Employees of the association, hiring the attorney. Oh, Jeff, we're going to have you come out, but we have 2 other law firms coming too because we have to bid. No, you don't. Accountant, architect, community association manager. We're going to interview 3, 4 management companies, but they already like Campbell. Well, if they already like Campbell and they're happy, why continue along? They have a good company. They're not required to do the bidding. Engineer, landscape, architecture. However, all these contracts must be in writing. And a contract with a manager or management company, if made by competitive bid, may be made for up to 3 years. Okay. That's enough on bidding. There are some rights that the members have if you are hearing impaired. Contract entered into by the board for communication, your bulk cable contracts, think of that, shall be deemed to include, and if they don't, they're deemed to include the following. Hearing impaired or legally blind parcel owner who does not occupy the parcel with a non-hearing impaired or sighted person can opt out of that contract. The association will still owe the same amount of money. A parcel owner who receives supplemental security income under Title 16 of the Social Security Act or food assistance as administered by the Department of Children and Family Services may discontinue the services without incurring disconnect fees, penalties, or subsequent service charges, and may not be required to pay any operating expense charges related to the service for those parcels, and the remaining expense is then apportioned out against the other dues paying members. Use rights suspensions, voting suspensions, and fining. 2 categories we're going to talk about. One is use rights suspension, voting suspension, fining, for failure to pay a monetary obligation. You didn't pay the assessment, now we're going to fine you. I never really understood that philosophy. They didn't pay the assessment. What do you think fining's going to do? But if you think it's going to do something, have a good time. And there's a process for that. Best thing you can do when it comes to people not paying, and members not paying their assessments, have a consistent written policy. Your declaration, more likely than not, says the date of the bylaws, the assessment is due. It may even provide for a grace period. Here, I'm going to give you an example where the dues are due on the first day of the month every month. That's all the guidance we get in our governing documents. So the board adopts the rule. And it said, well, it's due on the first. But we, the board, we're going to consider, in our policy, we're going to consider it late on the 10th. And on the 10th day, manager, you are instructed to automatically send a letter to the owner so that they're late. And then, if it's not paid within 30 days, it needs to automatically go to the association's law firm who's doing the collections, because in order to foreclose, you can't just foreclose on someone's house when they don't pay assessments. There's a process. You have to first, as lawyers, right? Once you are at the point where you finally send it to the lawyer, now it's at least 90 days by law. Practically speaking, it works out to between 90 and 120 days, realistically. But the first letter says, hey, you didn't pay yours from the lawyer. You're delinquent in paying your assessments. If you don't pay them, we're going to report a lien against property. And we have to wait for HOAs 45 days, condos 30 days. Then, assuming the member doesn't pay, we send a second one. Here's the lien we are recording against your property. If it is not satisfied within, and again, HOAs 45 days, condo 30 days, then the association is going to foreclose your property. We have to wait the requisite period of time, and then we can start the foreclosure. So you get a 90-day hold right out of the gate. So get a policy in place if you don't have one. And the sooner you have a strict policy where you're not having to consider what to do about Joe when he pays his assessments, the faster Joe's probably going to pay, because Joe knows, as every other member knows, hey, we got a 10-day grace. After that, manager sends a letter. After that 30 days, it's going to the lawyer. Or maybe it's 15 days that the manager has it, and then it goes to the lawyer. Whatever policy works for your community. Now let's go back into the authority to find and impose use right suspensions for everything but money. Everything but being delinquent in a monetary obligation to the association. And if the process I'm about to describe to you comes from the law, if your documents have a different process and you decide to find someone and we're in court on the issue, if you follow the process in the law but not the documents, if you follow the process in the documents but not the law, what do you think the defense of the offending owner is going to be? You kind of gave them the defense, right? You didn't follow the right process. So, if what I'm about to explain to you differs from what may be in your rules and regulations or your declaration, then you need to find parity. And you need to hit all the steps of the statute. You need to hit all the steps of your governing document somehow, some way, and your lawyer can help you string that all together. I want to put that out there. So, statutory process. First, the board sets the fine. Then, the member is sent a letter, and it says when the fining committee is going to meet, and it's at least 14 days later. Fining committee must meet. Fining committee can only say yes. I mean, they can say other things too, but it equals a no. So the board fined the owner $100 for the 5th time he didn't bring in his garbage can, we're tired of it, so on this 5th occasion, we fine him $100 every time he doesn't bring in his garbage can. He didn't bring in the garbage can, management company got a picture of it, board discussed it at the board meeting, fined him $100. The next day, the manager drops a letter in the mail, says on June 15th, which is 20 days from now, the fining committee will be meeting. You don't have to attend, you can. The fining committee doesn't meet. It's not an optional issue here, okay? It's not if you want to meet, let us know. No. Fining committee has to meet no matter what. And if fining committee says, 50 is too much, 100 is too much, we're going to make it 50. That's a no. If the fining committee tries to change what the board did, the punishment, if you will, it's a no. All they can do is affirm it. Anything else they do is a no. Everybody clear on that? Good. So, the hearing, the fining committee, must be held before a committee of at least 3 members appointed by the board who are not officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee. Role of the committee is limited to determining whether to confirm or reject. That's it. HOA, your fine may not exceed $100 per violation unless otherwise provided in your governing documents. That fine can be levied on each day being a continued violation, but that $100 a day fine cannot exceed $1,000 unless you have allowed for it in your governing documents. You can only lien for a fine if the fine gets beyond $1,000 and you have that authority in the governing documents. So we have to amend the governing documents in order to create the ability for a HOA to be able to lien a parcel for failure to pay a fine. The only other option is to take them basically to small claims court. Condos, that's pretty much what you're doing because you cannot use the foreclosure process. You have no mechanism to do that. So there we go. The fine is due 5 days after the fining committee has met. Now, use right suspension for failing to pay a monetary obligation greater than 90 days. So I just changed it up a little bit, all right? Now we're going into use right suspension for failing to pay a monetary obligation greater than 90 days. 90 days greater than 90 days. Through board action, the association may suspend an owner's right to use the common area facilities if greater than 90 days delinquent through board action at a properly noticed meeting. All right? I'm at the board meeting. I move anyone greater than 90 days delinquent no longer be allowed to use the clubhouse. Does that mean on the 91st day the clubhouse, my access to, or the delinquent member's access is turned off? No. Because what's the first thing that has to happen? The manager has to drop a letter in the mail telling the delinquent member that, hey, you're greater than 90 days delinquent, board passed a motion, anyone greater than 90 days delinquent no longer has right to use clubhouse, your clubhouse access is hereby revoked until you become current in your assessments. Now we can turn off the fast pass as soon as the manager drops it in the mail. Even if they haven't received it, technically speaking, we can still turn it off at that time, so long as we have dropped that notice in the mail. All right? Written notice is key. You cannot, when you suspend use rights, you cannot suspend, and it doesn't apply to, that portion of the common area used to provide access to the parcel, utility services to the parcel, nor can it prohibit vehicular or pedestrian ingress and egress going to and from the parcel, including the right to park. In other words, if you only have one way in, you can't turn off the clicker. If you, however, have a fast pass lane and the lane where the slow lane where you have to show your driver's license, you can turn off the fast pass lane. You can still get in. You're just going to be inconvenienced because you've got to wait in line like any other visitor. All right, everybody clear on that? Good, good, good. You can, I get asked this one, what if the board adopted a schedule of fines? That's an interesting question. Generally speaking, it appears to be okay. So the board comes up with a series of fines for failing to clean the roof, failing to bring in the garbage can, speeding, you name it, the list goes on and on and on. Here's the fine. And the board adopts that schedule at a promptly noticed board meeting, and the member is fined as a result. I have not seen a court case yet where someone has brought up the defense that the fine itself against that particular member was not adopted by the board, but rather the board adopted a schedule of fines. And therefore, you can come up with some argument as to why the schedule didn't comply with the law, some creative legal argument. I don't know. So if you want to use a schedule of fines, all I can tell you right now is I'm not aware of any cases that say you can't do it. And there's a little bit of risk in doing it, in that if you're in a courtroom situation, someone could try to defeat that particular fine by giving a creative legal argument. Voting suspensions. I suggest you do these on a case-by-case basis. You can suspend someone's vote for failing to pay a monetary obligation greater than 90 days. But what if the people whose vote you're going to suspend, for whatever reason, were going to vote in favor of what you were going to do? So it really needs to be calculated and thought out. So you always want to have the conversation at the board level with the manager present. Do we have any delinquencies greater, like maybe a month or two before the election when you're gearing up? Do we want to suspend the voting rights of members who are delinquent greater than 90 because manager needs time to get the letter in the mail to tell them that, because they're not, that vote is not suspended until, once again, manager drops that letter in the mail. When you suspend somebody's votes, it's as if they don't count. So, let's go back to our former conversation. We have 100 members. Sadly for us, 10 of them are delinquent greater than 90 days. We have suspended the vote. We need, for whatever reason, a majority of the entire community to pass whatever it is we're working on. Not a majority of a quorum, but a majority of the entire community. How many votes do we need? You got it. I knew I expected you to get it. If you don't count those lots, it's as if they don't exist. We had 100, we suspended 10, we now have 90 for that vote. We only need 46 in order for the measure to pass. Covenant enforceability and dispute resolution. Architectural standards, age restrictions, pet restrictions, restrictions on leasing and sales, guest and occupancy restrictions, parking restrictions, nuisance conduct. Those are the main reasons we typically take an HOA member into court when a homeowner association authorizes it. With condominiums, you are going most often, in many of your disputes, in the division of condominium for mandatory non-binding arbitration. Mandatory non-binding. You got to do it, but it doesn't matter. Sort of. Mandatory because you have to do it. Non-binding because if either party is unhappy with the decision from the arbitrator, they have 30 days to take it into circuit court. That's why the non-binding comes in. But HOAs are different. We go right to circuit court with any of these items. However, there is a condition precedent that must be followed. And I didn't think it was going to work, and I am a believer in required pre-suit mediation. I'm pleased to report that 90% of all the disputes between an HOA and a member get resolved at, what seems to be anyway, pre-suit mediation. It's a relatively simple process. I was trying to find the process for you. Bill. So, pre-suit mediation procedure. Really? Except that, the wrong screen. Great screen. Pre-suit mediation procedures. A member is upset with your association is upset with a member. Either way, you have to send them a statutorily compliant letter that says you're taking advantage of the pre-suit mediation process. You have to provide the name of 5 mediators and their rates. That person is obligated to pick one of the 5. You can try to negotiate around it, but at the end of the day, you can force them into one of the 5 that you presented. If they fail to respond, you can go right to court. They have 20 days to respond to that written offer to participate in pre-suit mediation. The parties split the cost of the mediator's fee. That's how that works. And it really has worked out pretty well. There is a new statute that came out a few years back. I shouldn't say new, it's old now. But before commencing litigation in the name of the association involving an amount in controversy greater than $100,000, the association must obtain the affirmative approval of the majority of the voting interest at a meeting of the membership at which a quorum is present. That's a whole bunch of legal gobbledygook language here that simply means the majority of the quorum. So if you ever see it worded that way in your declaration, it's a really good example of it. Must obtain the affirmative approval of the majority of the voting interest. Here's the key language. At a meeting of the membership at which a quorum is present, you now pretty much know they're talking about a majority of the quorum. But if you're going to sue, the amount of controversy is greater than $100,000, you will need the community vote. This only applies to HOAs, not condominiums.
Answer me. You've got a call.
What did I say? Answer. You've got a call? I love it. Yeah, they really do. Prevailing party attorney's fees you only get if authorized by contract or statute. 90 80% of the time, 95% of the time, when you're suing over something in the declaration, it is a covered item, and the prevailing party will get their prevailing party attorney's fees. You're never made whole. So know that going into it. You get close to it, but never 100%. It's really annoying. You know what? This is my punishment for not giving you guys the presentation in advance. Pretty close. Been doing this with this device for a couple of years. That's never happened. It's really strange. I'm going to leave the bottom slide. Oh. All right. Architectural standards. True case, true story. An owner's son retains me. Owner wants to paint their house pink. The association won't let her paint the house pink. Well, by the time we were done, she painted her house pink lawfully. Why? Because the association did not adopt paint standards. And the law says in 720-3035, if you hope to have an architectural standard, you better put it in writing, because if not, you don't have it. I have drafted some language that I put into amended and restated declarations that says this. In the event a member makes an architectural request and the association has not adopted guidelines and standards regarding that item, then the existing condition of the community is the standard. So, in that case, had they had that language, somebody wants to paint their house pink, we have no pink houses, therefore she can't paint the house pink, she could only paint it a color of an existing house in the community. Make sense? So it's catch-all language for those situations that you want to have in your rules and regulations or you want to have in your declaration. Now, bottom line, treat people the way you want to be treated. Official records. Oh, I could read this whole big long list to you, 1 through 9. Let's just jump to number 9 because it says it all for us. All other written records of the association not specifically identified in the statutes that relate to the operation of the association. All records. You basically have 10 days when an owner makes a request for the official records and they put it in writing and they follow they jump through the hoops. You have up to 10 days to provide access to the record. You don't actually have to provide the record. It's been a little challenging since we have computers now. In the old days, you had a cantankerous member. They made an official record request. We put, 10 bankers boxes, 20, 30 on a table. Here's the records, have fun, tell us what you want. You have no obligation to cherry pick the records for the requesting owner. Their request has to be specific to inspect the official records of the association. On a hyper-technical level, they send in a letter, I want the manager contract, you don't respond. They haven't really triggered the statute. You have no obligation to provide the contract. You have an obligation to make the official records of the association available. So, I make a request to see the manager's contract, or to get a copy of it. In the letter, if I'm representing somebody, the first sentence I'll have is demand to inspect the official records of the association. However, to obviate the inspection, please just send over a copy of the manager contract. Works 90% of the time. All right. You've got to keep your official records for up to 7 years. Condominium change. Meeting minutes now have to be kept from inception, always, never thrown away. But that's just conduct. Other than that, it is a 7-year default, except for the board certification certificate, which is 5 years. We do have records that are not accessible to the members, including attorney-client privilege, work product, medical records of owners, information obtained in connection with the lease, sale, or transfer of a parcel, personnel records of management employees, electronic security measures, software operating system, personal identifying information other than basically name and address within the association and wherever they're having, whatever address they're using for official mailing purposes. You cannot provide driver license, credit card, fax, telephone, social security numbers, email addresses, et cetera, et cetera, et cetera. You could provide email addresses. If you're using email, you've adopted it as the official means of communication. Now then, that would shift it, and it would be disclosable to the member making an official record request. Many times I get a question, it's really misunderstood. Records protected by attorney-client and work product. I'm a member of the association, Mr. Lawyer, you work for me. No. I say to the member, board member, you work for me. No. I work for the company. I work for the association itself. That is my client. When I send a letter, it is to the board, an opinion, attorney-client privilege. I can never share that information. The board can. Maybe the board wants to share a letter from the lawyer with the members about the parking situation. Two things. One, if it's a letter I've written, that could be problematic. Because I probably put the good and the bad in the same letter. Well, these are the reasons you can do it, these are the reasons you can't do it, here's how I'm never going to attack it, here's what you need to do to prevent it, and then got a lot of strategy in there. In the wrong hands, that could be a lot of dangerous information. Some people will tell you that after litigation, everything is discoverable as part of an official record request. No. The advice letters from the attorney remain sacrosanct forever. Only the board, acting as a board, can choose to waive the attorney-client privilege. I move we share Jeff's letter with the membership. Okay, get a second vote, conversation, etc. So you can waive it if you want to share it. I would suggest to you, though, you probably want a different letter to share than the original one said, because you probably want a letter that is more geared toward a particular point of view, rather than teaching the members how to nitpick your heels and defeat what you're trying to do. The reports in the litigation. Can the members see those? Yes, those are work product privilege. So during the litigation, off limits. After the litigation, part of the engineer's report. After the litigation, then it's open to the members for official record inspections. Okay. A lot of stuff here you can talk about. Anybody in here in a no-pet community? Right, show of hands. Anybody in here dealing with assistance animals? An assistant animal request, a few. You're going to take that slide home with you. It's okay. There is some other great information on official records that I really don't need to go through this morning. Assessments and foreclosures, what I want to talk about is just if you don't have a way to log in to your attorney's computer system to see the status of your collections and foreclosures, you're missing out. I know all of our clients get a login and password, and you can then see to your heart's content what the status is, what's happening in the matter. You never have to call, you never have to wonder. New procedure in the law. It's a motion to show cause. Applies in the foreclosure setting, can be made by any party, and is extremely important. If the property is vacant, and by vacant I mean the owner isn't living there. Don't ask me if a tenant is living there, does that mean vacant? I don't know, because the actual legislation of what I'm about to tell you says if the home is non-owner occupied. So I don't know, we don't know if it applies to tenants or not, but if the home is non-owner occupied, it's worth a shot. Even if a foreclosure takes 9 months to a year and a half. What if we get it done in 8 weeks? That's using the motion to show cause process. But the key is the home has to be non-owner occupied. And whether a tenant can be in the home or not, they don't have a good answer for that. I'm just going to roll the dice and find out. But home is non-owner occupied. Anybody can write a letter to the judge, motion, judge, please issue a motion to show cause. Judge then sends a letter to all parties in that foreclosure litigation. Says, tell me why I shouldn't waste the court's time any further. Stop this nonsense. Give me your defenses. If the court, in reading those letters and responses, doesn't think that the homeowner has what's referred to as a justiciable response, a legal defense to the foreclosure, then you can just take the property and give it to the foreclosure clerks to put into the next auction cycle. So that takes a residential assessment foreclosure or bank foreclosure. Remember, any party can make the motion. So typically, you guys are sued, your association is typically sued in a lender foreclosure action. So just know that process is there, and if the home is not owner occupied, you have a conversation you can have with the attorney if the owner is delinquent in the collection of assessments. I have all kinds of wonderful information for you on assessments and collections that we could spend days talking about. You have the pleasure of reading it at home. So please be sure you do. That's the slide on the order to show cause. If you have an owner who isn't paying their assessments, but has a tenant We can make a demand on the tenant, statutory demand, have to do it the right way, but tenant, you are hereby directed to pay your rent to the association. If you get too much money that exceeds the assessment amount, then the difference would obviously have to be refunded to the owner of, or to the owner. It would go to the owner. There's all kinds of penalties. Landlords can't interfere in this process. I've heard every excuse in the book. I don't pay rent. It seems to come up more often than not, or I'm here as a guest, to which I say, tell it to the judge. If you suspect the person is lying and isn't really a guest, then you just let the lawyer know, and you can take it all up to the judge and let them prove it to the judge. Otherwise, we're going to make sure we get the rent for our association clients. Receiverships, we don't need to go into. Insurance, 4 slides on insurance. I highly recommend you get flood insurance. Officer director liability insurance does not automatically cover committees. What about committee member indemnification? Do you have an indemnification requirement in your governing documents that cover the officer and directors? Do you have indemnification for your committee members? It's all governed by the documents. You might have an insurance product that provides indemnification for committee members, but not an obligation in the declaration. And vice versa, you may have an obligation for indemnification in the declaration that, for whatever reason, oops, you forgot to insure. And so now, if the committee member is sued, you could have had insurance for it, but you don't. You have the affirmative indemnification requirement. Well, now the association is going to have to pay for that committee member's defense on whatever the issue is, because it's an obligation to indemnify. Did I mention get flood insurance? Did I mention you should buy flood insurance? Did I mention you should buy flood insurance? Even if you're in a D zone, yeah, I think you should. If you're going to choose not to get flood insurance, I kind of think that maybe you should have a conversation with the membership about it, so you're not left holding the bag on that. So you're in a non-mandatory area. Should we have flood insurance or not? Well, 50% of all the floods that occur in the United States occur outside of flood zones. Think about that. That's not enough to scare you. We're on swampland. Okay. That's it. I want to spend a couple minutes on the Federal Fair Housing Act. And I think we're about at the end, and we'll take whatever questions you may have. Federal Fair Housing Act is different than the ADA. I want you to picture somebody who's blind, you have seeing eye dog, and they're outside the community association gate, making their way on the public street. That is ADA. The airlines, the bank, Publix, ADA. ADA has no assistance animals. They have service animals only. Dogs and miniature horses. That's it. Why miniature horses? And it took me forever to find out, but I did. You live in rural areas. And the miniature horses are incredibly intelligent, last a really long, and they have long lifespans. So they're great for people who have certain disabilities. And you have the room for a miniature horse. How do you get a miniature horse in the condominium elevator to go to the clubhouse on the top floor? It's an interesting question. That's where a condominium association, or homeowner for that matter, you open up your gates, you rent out your clubhouse to anybody in the world. You don't have to be a member to rent our clubhouse. You have just subjected all the public common areas to the ADA. So normally ADA does not apply. FHA does. FHA has the service animal and the assistance animal, otherwise you guys know as the emotional support dogs. Okay. Here's how you qualify for an emotional support animal. Have a disability that affects your major life function. Animal helps ameliorate the disability. Jeff is depressed. It affects him at work. Having the animal at home makes Jeff more productive at work. That's it. Signed by the doctor, psychiatrist. I win. I qualify. That easy. There's a lot of, you can tell, there's a lot of abuse going on with our assistance animal. The assistance animal could be any animal at all, practically. No requirements there. Yes, you can get rid of the assistance animal if the animal is a nuisance. Growling doesn't cut it, fighting does. The owner of the animal would be allowed to get a replacement animal if the animal has a nuisance. You should not adopt one set of rules governing all FHA animals. Why? Well, because you could find yourself in violation. If you say you have to clean up, all the assistance animals have to go to the bathroom over there, and you got to clean up. And this assistance animal is a service animal for a blind person. How can they comply with that rule? They can't. Right? So you got to have flexibility in your rules. You got to be very, very creative and very careful. Most often, you are covered by exercising your reasonable business judgment. However, what that means is if somebody sues you in your personal capacity, more often than not, that case can get dismissed very, very easily because you were acting in your corporate capacity. So the suit against the association goes on, the suit against you as a director of the association goes on, but the suit against you as a person, not a director, is ended. All right. Except when it comes to fair housing. You have personal liability on fair housing. The best advice I can give to you is this. If you're going to say no to somebody making a request for a reasonable accommodation or reasonable modification, maybe they want a wheelchair ramp somewhere, you're inclined to say no. If you're going to say yes, move on with life. If you're going to say no to any of these requests, bring in the lawyer. This is the one big area of law where you guys have personal liability on the board, for sure. So you don't want to test out those limits. You don't want to be the test case, right? So make sure you bring it for legal review so you can hide behind advice of counsel. Sir?
If you resign or you're no longer on the board, does the suit carry on as you
Yes.
acted in the capacity?
Yes, because the suit carries on.
Okay.
And you still might be involved here and there. Your deposition still might be taken.
Okay.
That kind of thing. All kinds of other great information on the Federal Fair Housing Act. Recall, we talked about a little bit. Takes a majority of the community to effectuate a recall. So do a good job. You can't be recalled in the first 60 days. You can't be recalled in the last 60 days. So for 120 days, you are interference from in the middle. Well, they can get you. So remember that if someone's going to challenge the election, it has to be in the first 60 days. All right. Questions?
Become a board member and you discover that there is one or more properties significantly behind in paying maintenance fees and assessments, and you find that previous boards have not handled delinquencies as required by the documents. What would you suggest?
Well, and that's, what do we do when we have a covenant that we haven't followed in our governing documents? We simply put the community on notice, starting on this day, whatever it's going to be, a couple weeks from now. We are going to start enforcing it, and here's the process. At a minimum, you're going to send a letter to everybody in the community. We have a no-dog rule, we've been allowing dogs, we're going to start enforcing it. Here, those of you with dogs are grandfathered, those of you without dogs, well, no new dogs, starting in April 1st. Other questions? Sure.
Many HOA communities have restrictions on rental. In other words, you can only rent twice every year for 2 months for a minimum of rent. I understand this legislation in committee now that's trying to get out of.
Last time I saw the bill, it exempted the associations. We had a massive undertaking to get to have that legislation, so it would not affect our businesses. So if you want to be 100% certain, because you never know what's going to happen in legislation until it gets passed, you have plenty of time between now and July 1st to amend your governing documents to say no overnight rentals such as Airbnb. Put that into your covenant. And then, even if they adopt something in Tallahassee, they can't compare your existing contract. You're protected. No.
So, my concern is.
Yeah, that's only those who got grandfathered. If you had a no pet requirement in the documents, we ignored it. People got pets. Can't really tell them to get rid of your pet. We can't say we're gonna start enforcing it next week. So if you have a pet, let us know what it is, so we can enforce it. That's fine if they have an assistance. How long have you been aware of it?
To be honest with you, she is.
Well, if you're aware of it for 5 or more years, you're done. Nothing you're gonna do about it. If it's 5 or more years, you have a 5-year statute of limitation. Not a black and white answer, but generally speaking, yeah, but maybe. You guys have been wonderful, so thank you.